8:37 is the start time. It's good to see everybody. We'll begin with invocation to Vice Chair Butler. Would you mind?
Yes, sir. Thank you, Mr. Chair. Lord, we come together today to do your will, to do your work for the great citizens of this wonderful state. Lord, we're blessed that we have the freedom to gather, the freedom to air our grievances, and the freedom to do so as we choose, Lord. Thank you for getting us here safely this morning. So many people have gathered from various parts of the state. We ask for your grace and mercy on our ride home, that we all arrive safely to our families and our loved ones. Lord, help us as we do your will today. Lord, sometimes things don't go our way, but there's an understanding that we don't understand, greater than ourselves. And Lord, we ask that we be part of your plan, not that you be part of ours. In your holy name, we pray. Amen.
Thank you, Mr. Commissioner, roll call, please.
Yes, sir. Commissioner Sujit Rakharam,
Present.
Commissioner Lori Hyde,
Present.
Commissioner Nora Castaneda,
Present.
Dr. Barry Wesson,
Here.
Dr. Ray Callis, Vice Chair Tom Butler,
Here.
Chairman Rick Figueroa.
Here.
We have a quorum.
All right. Thank you so much. Real quick, do we have anybody online?
No, sir.
Okay, I want to make sure. Commissioners, we're going to go to item C, public comment. We are accepting public comments in writing in person. Commissioners, we received, I think, 5 public comments. Those have been provided for you. So if anyone's wishing to address the commission on a matter that is not on the agenda, if you are here for a contested case or a rule, we'll call upon you when we get to that agenda. If you want to speak, please fill out the form, come in the public comment form. And again, you'll have 3 minutes to speak. Christine will keep time.
Yes, sir.
Okay. First one will be Michael Parker. Harper, I'm gonna read you some instructions before you start, if you don't mind.
Perfect. I'd say it. First one, a lot of pressure.
Out of the gate.
Out of the gate.
Thank you for being here. Please say your name and who you represent. You'll have 3 minutes to speak. Please understand that the commissioners are not allowed to ask questions or engage in a discussion with you about anything that is not specifically on our agenda. Please also understand that the commission cannot hear any information about any pending complaint or enforcement case because we may ultimately be the decision making in the case. You understand?
Yes, sir.
Great. You have 3 minutes. Go ahead and go, sir.
Morning, everyone. My name is Michael Forsberg. I'm here on behalf of the QABA Credentialing Board. I am also a behavior analyst. I've been working in the field of applied behavior analysis for over 12 years. During this time, I've dedicated my career to supporting individuals with autism spectrum disorder and supporting their families. Throughout my experience, I've had the privilege to see the transformative power of early intervention and how this therapy is so important for these individuals. Early intervention in ABA is not just beneficial, it's crucial, particularly in the age range of 2 to 6 years old. Research constantly shows that therapy within this critical window can significantly enhance the developmental outcomes for a child. This period of life for an individual is so important because the brain at that point can learn and absorb so much more information. Skills that many of us take for granted, such as communication with others, forming strong relationships, can be really developed more effectively during this time when appropriate therapy begins. By capitalizing on this early start, we can lay the foundation for the individual to have lifelong benefits and substantially reduce potential challenges later in life. The impact of ABA extends beyond the individual. It can also transform families. Parents and siblings witness remarkable progress, from the joy from a child uttering their first words to completing tasks independently. These milestones are monumental, and they foster a nurturing environment where not only the child, but the entire family thrives. ABA is pivotal in creating these moments by offering tools and strategies unique for the child and their family. Despite the proven benefits of ABA, access to care continues to remain a significant barrier for many, many families. Many families face these hurdles in accessing therapy due to insignificant insurance coverage, long wait lists with providers, and a scarcity of available and qualified specialists and clinicians. These delays in access to care cause individuals to miss out on critical time windows of their life where the most progress can be made. By incorporating the QABA certification into the licensure requirements, we can significantly widen the pool of qualified practitioners ready to assist families. This expansion would grant families greater freedom in selecting a provider tailored to their specific needs and that can support their family. In conclusion, the essence of our work in ABA and the broader mental health field is to allow individuals to reach their ultimate potential. Every child and adult with autism or any other diagnosis has the right to lead a fulfilling life. It is our duty as a society and as practitioners to ensure that these individuals and their families have resources and supports do just that. Thank you for your time.
You started her. Great lead off hitter.
Thank you.
Great job.
Someone call me Jose Altuve.
I would go that far. Would you be single?
Okay, thank you.
Great job. Thank you. Andrew Patterson. Mr. Patterson, did you hear the instructions I gave?
I did, yes, thank you very much.
Go ahead, you have 3 minutes.
Okay, I'm Andrew Patterson with the QABA. Good morning, members of the board. My name's Andrew Patterson. I stand before you to discuss an important matter for the community, which is imperative for the expansion of Texas ABA, which is Applied Behavior Analysis, licensing to recognize the QABA board. This is the second largest certification board in the United States. Currently, the Behavioral Analyst Certification Board, the BACB, maintains what is effectively a monopoly on the practice within the state. This limitation not only restricts professional diversity, but it also directly impacts the availability of care for children with autism. How it impacts the military families. So consider the case of military families, many of whom are required to relocate multiple times over the course of their service. Texas, being home to a significant military population, sees this scenario frequently. Military spouses who are certified under the QABA from other states such as North Carolina, which includes it in their licensing, find themselves unable to practice upon moving to Texas. This presents not just a professional roadblock for the individual, but also denies essential services to those in need, particularly at bases like Fort Hood, which has one of the longest wait times for children with autism. Our appeal is simple yet profound. Expand the licensure to include the QABA certificate holders. This act of inclusivity is not without precedent. States like Colorado, Florida, Washington, California, and Georgia have already taken similar steps. The benefit to the community is enhanced access to care. It will immediately increase the number of qualified professionals able to provide the critical ABA services, reduce wait times. With more providers available, wait times for therapy will naturally decrease, bringing timely intervention to those in need. And support for military families. It will significantly assist military spouses, ensuring their professional certifications remain valid and their livelihood secure despite relocations. We request the board to recognize the urgency of this situation, considering both professional stagnation imposed on QABA certified individuals and the far-reaching impact on children with autism who are currently underserved. By extending licensure to include QABA, Texas can lead by example, showcasing its commitment to accessibility, diversity in professional practice, and the unyielding support for military families. Thank you very much.
Gotcha. Thank you. I appreciate both of you gentlemen for what you're doing for that effort. Ms. Ross. Understood instructions earlier?
Yes, sir.
Okay. Go ahead, 3 minutes.
My comments are for the Texas Veterinary Board.
Yes, ma'am.
So the Vet Board is a consistent pattern of chronic failures, allowing vets with prior histories of deadly outcomes to continue to practice, leading to more unnecessary preventable deaths. I filed my complaint in April 2020 as a result of the preventable death of my beloved dog Pirate under the substandard care of Casey Farazano Singletary. The poor substandard care and multiple violations, coupled with her dishonest and misleading exchange with both myself and my husband, led to an outcome that terminated Pirate at a young productive age. She consistently and intentionally lied to us, violations 801, 402.
Ms. Ross, can you just give me a second? One second.
Yeah.
Is this a case that's pending? Just give me a
No.
second. I'm not. I
It
apologize.
is not, Chairman.
Okay, thank you. I apologize. I want to make sure that we.
It's just- I've
Continue.
asked for a review, but
Okay.
it's not.
I'll give you
Yes,
the
sir.
time back for sure. I apologize. Go ahead.
Oh, no problem. She said he needed ultrasound, but it was not available. However, I found multiple entries that she conducted one and charted it was negative for bleeding. This critical piece of information was intentionally withheld from us and skewed our informed decision about his care. After we determined she was not placing Pirate's best welfare as a priority, we asked to have him immediately released to us with his medical records to transfer him to his private vet. She became verbally defensive and unreasonable. We were locked outside and never allowed to see Pirate the entire time. 45 gut mentioned rooms passed with no communication. She approached us outside and stated Pirate is bleeding to death, a fact that the official medical records prove false. I told her to go and get Pirate now as we're taking him to his vet for treatment. She told me he's dying, he'll never make it, he's going to choke to death on his own blood. He will die a horrible death. How can you do that to such a nice boy? You only have a few minutes to say your goodbyes. We were in total shock. Given her personal comments and information provided, we intentionally misled information. My experience working with the legal department under the direction of Brittany Sharkey was fraught with deception and disregard for rules and regulations and enforcement of laws. Neither Verrazano nor her attorney, Donald Farrell, also a licensed veterinarian, responded to the investigator, Mr. Juan Dawkins' multiple requests. After 60 days, Mr. Dawkins was forced to complete his investigative report without either the required cooperation, which is within 21 days. Mr. Dawkins documented multiple violations and potential investigative findings. I discovered Verrazano had a prior history of board violations resulting in the preventable death of another canine. I informed Mr. Dawkins as well as Brittany Sharkey. We waited 18 months for an IC on October 4th, 2021 via Zoom. Our attorney was not allowed to enter. During the IC, Dr. Quillivan stated, quote, "There are no standards of care in veterinary medicine." I brought up multiple questions as to Verrazano's actions. She assured me she would, quote, "get back to you." After talking to her, after a very short period, the Zoom link was disconnected. I sent an email to Sharkey, which was ignored. Dr. Quillivan never got back to me with any answers to my questions. Days later, Sharkey sent an email stating the board found no violation of the rules of professional conduct. All of Mr. Dawkins' extensive reporting and potential violation and investigative findings were totally ignored, as well as the multiple violations I found and reported. The vet board has failed to provide the required information 801-208C, quote, rationale for dismissals. I've made multiple requests and all been ignored. The TDLR must intervene and stop this deadly cycle of the vet board ignoring violations. Neither Verrazano nor Farrell have been held accountable for their blatant disregard for the rules of professional conduct. The vet board ignoring the facts in my case are both atrocious and unacceptable. It is clear that the vet board is not providing services to constituents, but instead providing substandard oversight of care through politics rather than enforcing regulations. The Texas Veterinary Medical Association is truly establishing policy and control in the Texas Board of Veterinary Medical Examiners. I would like to thank Dr. Gola, who has agreed to review my case, and I know he's had a lot to deal with, and I trust his professional expertise in reviewing the facts. Today has been 340 days since my email to Dr. Gola agreeing to do that, and 1,459 days since Pirate's preventable death at the hands of Verrazano, and this Sunday is the 4th anniversary of her deadly and intentional actions that took Pirate from us.
Ms. Ross, sorry for your loss. We appreciate you being brave enough to come and talk to us. Thank you. Mr. Larry Gonzalez. Mr. Gonzalez, did you hear the instructions earlier?
Mr. Chairman, I did.
Okay, go ahead.
Thank you very much. My name is Larry Gonzalez. I'm here today representing myself as the author of House Bill 26 and as a sponsor of Senate Bill 589. Good morning, Mr. Chairman and Commissioners. My name is Larry Gonzalez, and I served in the Texas House of Representatives from 2011 to 2018. I'm here today to publicly address how the Behavior Analyst Advisory Board, in 6.5 years, has not correctly implemented House Senate Bill 589 from 2017 as it was contemplated, debated, and passed by the Texas legislature, and how the advisory board has kept most of our vulnerable autistic population, our most vulnerable autistic population, without all the tools they need to be successful, contributing members of society. One of my main efforts as Chairman Gonzalez was to help the autism community in every way possible. Why? Because my son has autism, and I know the daily struggles he suffers through, and it was my mission as a legislator to make his life and every life just like his a little bit easier. My goal was to make these kids happy, productive, contributing members of society. In 2017, I authored House Bill 26. We later passed its companion, Senate Bill 589. This bill licensed behavior analysts and assistant behavior analysts in Texas. The Texas Senate passed the bill 25-6, and the Texas House overwhelmingly passed the bill 121-25. Why was the bill necessary? Medicaid would not reimburse for behavior therapy unless the behavior analysts were licensed, and in Texas they weren't. We knew people with money could pay out of pocket for autism behavior therapy. Thanks to another bill I passed, we knew people with health insurance could get their kids the help they needed for autism behavior therapy. But the Medicaid population, the most vulnerable population, still did not have access to this behavior therapy. For 6.5 years, the Behavior Analyst Advisory Board has ensured they still don't, not to its fullest. As one chairman of the House recently told me, in a time when we need more therapists, why is TDLR making it more difficult to get licensed? I have been assured by this chairman the implementation of Senate Bill 589 will be addressed as an interim study this year. One item we'll address is how the Behavior Analyst Advisory Board has created a vendor bill in Texas. As you know, the legislature does not create vendor bills. As chairman, if someone brought me a rider or an amendment, they had to also bring me a list of vendors who would qualify, because we don't do vendor bills. To my amazement, the Behavior Analyst Advisory Board has created a vendor bill where one didn't exist as we passed it. Through rulemaking, Behavior Analyst Advisory Board has established that only one entity can license behavior analysts in Texas. When I dug deeper, I learned that every licensed member of the advisory board is licensed by that entity. The advisory board has moved the goalpost where only one entity can license in Texas. This was not the intent of the legislature. Maybe one day the advisory board will accept my invitation to have this conversation. They have not. If nothing else, I'll certainly see him at the interim hearing in the House.
Representative Gonzalez, thank you.
Thank you, Mr. Chairman.
Francis, can we follow up with this? We get a chance?
Oh, we definitely plan on it. One of the things we'll do is definitely meet with Representative Gonzalez and his folks, but also this is the perfect time. We're in strategic planning season. And these are the type of things that can be brought to us in this moment. So I appreciate it, and he's been great to work with in the past. We'll continue working with him.
Thank you for your effort.
Thank you, Mr. Chairman.
Thank you for your time.
Very much.
Shoma Ladd.
Morning,
Shima
Shima.
Ladd, I apologize. Shima Ladd.
No worries.
Do you understand what I spoke earlier as far as instructions?
Yes, I do.
Okay, you have 3 minutes, go ahead.
Okay. So I'm here really to request an update or addendum to the rules and regulations. I represent myself and the cosmetology industry. I've been in this industry for 25 years. Also would like to see if we can increase public awareness. So I'll just list 3 things real quick. So one of the things that there's an issue with salons or businesses charging the public for services that they don't actually give. So one would be reflexology. This is something I've heard for 25 years now. So just taking it upon myself to try to get that rectified. And probably many women in here who've been to the spa understand that that is a truth and a fact. As in cosmetology schools, I would also like to see this changed and updated in cosmetology schools, as they do not literally teach you how to do reflexology. They release you to do it, but they're charging for this, and that's not the service they're getting. And the general public they know this, but that's one rule I would like to see changed, just because it's the right thing to do. The other thing is dealing with salon owners who own spas or salons who are not licensed to do anything that we do. So we have them putting people in positions to create services for us to perform on the general public, but the services they put together are not professional and actually work in a negative way when it comes to dealing with the general public. I don't feel like us as licensed professionals should have to argue or dispute with someone who doesn't do anything that we do. There needs to be something in place that we can stand on, even though we say you should know TDLR rules. You should already know this. We shouldn't have to teach you these things, but we're still in the position of having to do that. And so, I've required even my spa, if you're gonna have an unlicensed person creating services that we perform on the general public, it needs to be reviewed and approved by a licensed professional before you hand that to licensed professionals, because it's always gonna be a headbutt. So I don't know if they're not reviewing the TDLR rules, or if they think because they own this spa, you do what we say, but there needs to be something there where there's a better understanding when it comes to that. Also, dealing with human trafficking. So when we have these young ladies come in or whatever, even with our CEUs, you train and you teach to what to do, call human trafficking, what to do when these situations occur. But I would like to see more detail. So what do you do when the pimp or the John or whoever snatches your client out of your chair and you may be feeling intimidated? You may be feeling some kind of way. So I feel like that education needs to go a little deeper, a little further. And also just more public awareness on, I can tell you how many clients come to me on a daily basis with some type of trauma that happened. And when I ask them, 98% of the time, they're gonna say, I was at an Asian salon, I was at an Asian whatever. So now I'm having to educate my clients that all of those people are not legal. Some of them post pictures,
Wrap it up.
okay, on other people's licenses or this is that. So my overall point is more public awareness, some updates to the rules and regulations, and just some changes when it comes to unlicensed professionals that own spas, thinking it's okay to use us to their whim when it's not in accordance with TDLR.
Ms. Ladd, business intelligence, industry intelligence is important for us, so thank you for taking time to talk to us about this. We appreciate the effort that took you here. Thank you. Is that, Yvonne, where you at? Is that it, or Christine?
Yes, sir, that's it for the public comments.
Excellent. Okay, commission, we're gonna move, I don't see a need for executive session, so we may need one later. If we do, we'll go ahead and call it. So we're gonna skip those items, and then we're gonna go to item G in the minutes. So we'll, your second? All in favor, say aye. Opposed? Motion carries. All right, we're gonna go to contested cases, item H. We'll read some instructions here, because if anyone here is appearing in person for a case today, we'll call you upon when the case is announced. We'll hear from the prosecutor first, then we'll hear from you. You'll have an opportunity to speak. Make sure you speak clearly, say your name and who you represent. Each side will have 5 minutes to speak. Christine, one of the staff, will keep time, and then we may have a 3-minute rebuttal if needed. Please understand the commission can only hear, and I want to say this clearly, can only hear information that is in the record from the case that was heard at SOA. So you must limit your comments to those matters that were presented at SOA hearing. I want to make sure everybody understands that. So we'll go to item H, number 1.
Mr. Chairman,
Yes, sir.
just because I enjoy interrupting, we do need.
You and my wife.
It's good company. We do need, this microphone is not needed, Brian. We do need to get a motion for Dr. Callis's absence.
Okay, okay.
Thank you so much.
Thank you for reminding me. Yes, please. I need a motion.
Motion to.
There's a second? Excuse me. All in favor, say aye. Aye. Opposed? Thank you. All right, so, item number 1 on H is Eldridge and Stephanie Moses, DBA lady, and then Morgan Cummings, prosecutor. Is there anybody representing the respondent?
I do not know. No, sir.
Okay,
Not
okay.
that I know of.
How many you have?
You want me to go or wait?
You know, you have, oh, yes, yes, yes. you have four.
Good morning, Commissioners. My name is Morgan Cumming, and I'm a prosecutor with the Enforcement Division. I recommend you accept the Administrative Law Judge's proposal for decision and assess Eldridge and Stephanie Moses an administrative penalty of $1,000 for operating a cosmetology salon without a license, and that the respondents offered, provided, and advertised cosmetology services for compensation. On October 8, 2021, the department's Public Information Officer, Tila Mange, filed a complaint with the department after having watched a news segment titled Keep Central Texas Working, highlighting Mr. and Mrs. Moses' salon designed for children. In the news program, Ms. Moses is seen applying color to children's fingernails and toenails. Ms. Moses checked the salon's license status before promoting the salon on the department's own social media pages and discovered the salon was not licensed. Per department procedure, Ms. Mange filed a complaint. Then the department investigator, Katerina Avila, reviewed the respondent's online presence and the on-site investigation conducted by Deborah Hicks. Ms. Avila observed the salon offered cosmetology services in the news segment, during the on-site visit, and a Groupon advertisement, its official website, its Instagram and Facebook pages, and in 15 TikTok videos. The administrative law judge found the respondents cleansed and or beautified faces with lotion and or clay, treated nails by polishing, tinting, coloring, cleansing, manicuring, pedicuring, and cleansed or treated or beautified clients' hands or feet for compensation, which all requires a salon license. The respondents made several arguments why they should not be required to have a license. Firstly, they argued the clients were only children under the age of 12, but the law rules does not provide an exemption to licensure due to the age of the client. Children are entitled to the same health and safety protections as adults. Also, several licensed salons have services and equipment specifically designed to provide cosmetology services to children. Next, they argued they provided the adults with disclaimers advising them that this was an entertainment business and not a professional salon. However, a salon cannot eliminate the need for licensure through a disclaimer. If this were the case, all licensing requirements for all the department's 37 programs would become obsolete. If any unlicensed person could convince a customer to sign a disclaimer waiver and then perform the regulated service. Third, they argued that they were only an entertainment business and that the clients were charged for party packages or entertainment experiences. The administrative law judge did not find this argument persuasive and found many of the services were advertised and offered independently of any party package, such as like mommy nails, like mommy feet, and simple service manicure and pedicures. Also, the admitted evidence showed the party packages were predominantly designed around cosmetology services, while other package components such as decor, costumes, and food served a collateral purpose. Significantly, every party package included a cosmetology service. Lastly, they argued the department unfairly targeted it, but failed to provide evidence proving this. As stated earlier, Ms. Mange saw the news program highlighting the respondent's salon, and she wanted to promote this on the department's own social media pages, but checked their licensure status first. Furthermore, during the on-site investigation of the salon on November 5th, 2021, investigator Deborah Hicks observed Clorox wipes were used to wipe down the stations. Clorox wipes are not a department-approved disinfectant with demonstrated bactericide, fungicide, and viricide activity that can destroy pathogens and bacteria to render an item safe for use. However, the department cannot pursue a fail to properly disinfect violation since the salon is unlicensed. Based on the evidence admitted, the department proved the respondents committed a total of 21 violations and could have assessed an administrative penalty of $21,000. However, the administrative law judge agreed with the department that the reasonable and appropriate administrative penalty to be assessed is $1,000 for a single violation, which is what is required by the enforcement plan approved and adopted by the commission. The department recommends you adopt the PFD as written and assess the respondents $1,000 administrative penalty for operating a cosmetology salon without a license to protect the public health, safety, and welfare from the hazards of unlicensed activity, and to ensure sanitation is properly performed to prevent the transmissions of bacterial, fungal, and viral infections and diseases. I am free if you have any questions.
Commissioners, any questions? I'll take a motion.
Chair, can I ask a question?
Yes, sir.
Children are involved in this one, which is a primary function of safety, as you mentioned right there. What was the reason why the enforcement requested only $1,000 when you had a range to $21,000?
We thought a single citation was the reasonable, because we don't want to put them out of business. We want it to hurt, right? But we don't want to put them out of business. We want them to come into compliance, which they refuse to do. So that's why we think $1,000 is enough to hurt and to deter other people from engaging in this type of activity.
So you perceive that others who are trying to get into this kind of activity would cease if they
We
do or
currently
be.
have several open cases dealing with the same kind of issue.
So assuming that it comes to the same conclusion right there, people are still continuing right there. So I'm not comfortable with the rationale of just, if you want to deter others, we got to have a little bit higher fine.
I'm
So that
looking for higher fine.
children are involved, that's the only thing.
I was gonna say, I think that's a good point. You know, if we've got others that are doing this, this is like a slap on the hand, and is that gonna stop anyone else from saying, hey, it's gonna take them this long to find me, and, you know,
Plus $1,000 is
Yeah,
probably
yeah,
what they
yeah,
make.
no, let them finish. Go ahead. Go ahead.
no, that,
Okay, go ahead.
I was just gonna say $1,000 is probably what they make for that event, so,
Close to it, yeah.
yeah. So I don't think you're hurting them financially.
Is there a motion or we need more discussion?
you wanna make a recommendation?
How to go with the PFD with the higher fine right there.
You want to amend the PFD for the hire?
We can amend.
Yes.
What do you want? What do you want to amend it?
I would put at least, this is the first instance, I think. Is this their first instance?
This is the first time they've been caught, yes.
Okay, you all recommend 1,000, I would add additional 5,000 to total 6,000.
So your motion is to,
I'll second that.
any further discussion on that? You want to amend the PFD, Doug,
Yes, sir.
to increase from 1 to 6?
I believe that's authorized since we have a number of violations.
Any further discussion? All in favor, say aye. Opposed? All right, motion carries. Thank you, Ms. Cummings.
Thank you.
Item 2, Lock Can Fam and Jessica Hurtado. Doug?
Yes.
Good to see you.
Good morning, Chairman.
You go ahead.
Good morning, Commissioners. My name is Jessica Hurtado, and I'm a prosecutor in the Enforcement Division. The ALJ recommends that you deny Lock Tam Fam's application to renew his cosmetology manicurist license, and that you revoke that license based on his criminal history. I ask that you adopt the PFD as written. In 2012, respondent pled guilty to aggravated robbery with a deadly weapon, a felony, and was placed on deferred adjudication for 10 years. However, in 2013, respondent's community supervision was revoked, and he was sentenced to 6 years in prison. In 2016, after being released from prison, the respondent applied for a cosmetology manicurist license. Despite his criminal history, the department took a chance on the respondent and granted him that license. The respondent renewed his license through October 2022, when his most recent renewal application was submitted. In 2020, respondent was involved in an altercation with other patrons outside of a restaurant. After being told to leave, respondent and his co-defendants waited outside for the victims to exit the establishment. Respondent initiated a physical altercation by punching one of the victims, and while the victim was on the ground, the respondent repeatedly kicked the victim while he lay on the ground, causing injuries to his head, neck, and shoulder. As a result of this incident, in May 2022, respondent pled guilty to robbery causing bodily injury, a felony offense. The court deferred adjudicating the respondent and placed him on community supervision for 5 years, and he will remain on supervision until May 2027. In October 2022, just 6 months after pleading guilty, the respondent submitted his application to renew his manicurist license. When asked if he had been convicted of or placed on deferred adjudication for any offense since his last license was issued, the respondent answered no. At the hearing, respondent offered no explanation for his actions and presented no evidence that he made any rehabilitative efforts. The ALJ notes that the respondent's offense is a serious one, a felony involving physical violence, and the respondent was 27 years old when his most recent offense occurred. Respondent's actions cannot be characterized as mere youthful indiscretion. Additionally, the ALJ notes that respondent provided no evidence to establish his current or past work activities, provided no letters of recommendation from members of his community, and has not complied with the terms of his current supervision. Finally, the ALJ found that in the absence of any evidence of rehabilitation, the respondent's past history represents a troubling and ongoing predisposition to violence. Aggravated robbery is a guideline crime for cosmetologists as a crime against a person. According to the guidelines, licensees have direct contact with members of the public in situations that have the potential to result in confrontational behavior. Thus, a person with a predisposition for a violent response does pose a risk to the public. The ALJ concluded that the evidence demonstrates respondent is not currently fit to hold a license, and the ALJ also concluded that respondent knowingly made a false statement on his renewal application. For these reasons, the ALJ recommends that you deny his renewal application and revoke Mr. Pham's manicurist license. I ask that you adopt the PFD as written, and I'm available to answer your questions. Thank you.
Thank you, Mr. Todd. Any questions? All right, take a motion.
Make a motion to accept it as written.
Is there a second?
Second.
All in favor, say aye.
Aye.
Opposed? All right. Item 3, Mark Mason. Jessica, did you-
Chairman,
Yes, sir.
there were some errors with the paperwork with the notice for Mr. Mason. And we would like to ask that we continue
A
this
continuance?
case today.
Okay.
Yes, so we can give him the correct notice.
Okay.
Thank you.
Commissioners, I'll take a motion for continuance.
So moved. Continue.
All in favor, say aye.
Aye.
Opposed? All right. Justin Perez. There's nobody on the respond? Okay, go ahead.
Thank you. Jessica Hurtado, Enforcement Division. As you will recall, Commissioners, this case was originally considered at your December meeting, where you voted to refer this matter back to the Enforcement Division to work with the applicant to issue a restricted license. In January, the department sought a continuance to allow additional time for the applicant to provide a proposed supervisor who could enforce the restricted license provisions that the commission sought to impose on the applicant. However, despite our best efforts to reach out to the applicant, he has failed to submit that proposed supervisor. As we have been unable to obtain this information, I ask that you reject the PFD and deny the applicant's apprentice electrician license application. In 2017, the applicant was placed on deferred adjudication for 6 years for felony sexual assault of a child. In 2019, the applicant applied for an apprentice electrician license. The department opened a case to investigate the applicant's criminal history, but due to an administrative error, that license was issued and the case was closed without ever clearing the applicant. The department learned of this error in 2020 when the applicant renewed his license, and at that time, the department initiated revocation proceedings against the applicant. Mr. Perez never responded to the department, and his license was revoked by default order. In 2022, the applicant again applied for an apprentice electrician license, which initiated the case before you today. The applicant was 20 years old at the time the offense occurred. The criminal conviction guidelines identify crimes involving prohibited sexual conduct and crimes against children as offenses that are directly related to the duties and responsibilities of an electrician. According to those guidelines, licensees have direct access to private residences and deal directly with the general public. Licensees may work unsupervised in homes, schools, daycares, or other locations where children are present. Clearly, the dangers posed to the public warrant a careful consideration of these guidelines. However, despite these clear guidelines, the ALJ mistakenly asserts that the applicant's offense is not directly related because there was no evidence that sexually assaulting a vulnerable child relates to the applicant's abilities to discharge the duties of a license holder, or that the elements of the crime correlate with those duties. This is simply wrong. You, the commission, adopted these guidelines after considering the factors in Chapter 53 as required by law. And the ALJ is wrong to second guess you, the commission, in that decision and find that the applicant's offense is not directly related. Further, the ALJ is incorrect to assert that because the applicant previously held a license without any reported issue, and because his criminal history appears to be, quote, anomalous, the applicant should be granted a license. While it is true the department made a mistake and granted Mr. Perez a license, that mistake should in no way continue to endanger public safety. The applicant's testimony and evidence at the hearing sought to establish that he did not commit this offense. However, the court found the evidence substantiated the applicant's guilt when the court placed him on deferred adjudication. Unless and until that judgment is overturned by a higher court, the applicant cannot assert his innocence now and in an attempt to attack that judgment in these proceedings. Because I still believe the public safety is at risk if the applicant is granted a full license, which will allow him to enter into homes, schools, and daycares and other places unsupervised, I ask that you reject the PFD and deny the license application. I'm available to answer your questions. Thank you.
Thank you, Mr. Tardo. Question?
I understand that this is the fourth time, right? When I hear that October 10th, he wanted to visit, but I guess he got continuance. Then December 1st, the case was tabled, so enforcement, y'all can work out, but he doesn't want to work, I guess that's the correct statement.
Yes, that's correct.
And in January, again, we tried to give a restricted license and he's been uncooperative.
Correct, Chairman. Commissioner, excuse me.
It's going around. Commissioner Hunt.
Did he give a reason as to why he wasn't interested in negotiating a restricted license?
My understanding is that he needs to get the information from his employer. Now, I don't know if his employer is just unwilling or unable to do it, but he has indicated that he's not able to get cooperation with his employer.
And Commissioner Hahn, this is Brian Francis.
Yes.
That master electrician is the one saying, I am vouching for this person
Yeah.
and I'm responsible for this person. And so that's a huge statement on their part to not.
I agree. We tried.
Any other questions? Motion?
Chair, I move to reject the AJL's recommendation to deny the applicant the license.
So deny the PFD.
And deny the PFD.
Point of clarification, Doug Jennings, General Counsel. I believe the motion is to modify the PFD.
Okay.
Modified
to deny the application.
Right, deny the application.
Right, and that will require some changes to conclusions of law and findings of fact.
It's 8, 9, and 10.
Conclusions of law 8, 9, and 10, for some conforming changes as well as finding of fact
16.
Yes, sir.
Second the motion.
All right, any further discussion? All those in favor say aye.
Aye.
Opposed? Motion carries. All right, Ricardo Level McNeely.
Go ahead. Nothing
Okay.
for me.
Okay.
Chairman, thank you. Jessica Hurtado, Enforcement Division. I'm happy to say that we were able to work out an agreement with Mr. McNeely after the commission's guidance at the last meeting. And so we have entered that agreed order and we're asking that you dismiss this PFD now.
Is there a motion to dismiss?
So moved.
Second. All in favor say aye.
Aye.
Opposed? Motion carries. Hurtado, thank you.
Thank you.
You Lions work, appreciate your efforts and what you're doing.
Thank you, Chairman and Commissioner. Thank you.
Okay, Commissioners, we are on item I, number 1, Calvin Walker and Mr. Jennings. And under Mr. Walker, DeGuerin.
Yes.
Mr. DeGuerin, do you remember hear the instructions earlier?
I did, Your Honor.
Or
Mr. Chairman, excuse me.
I got promoted.
Right, right.
Yeah, that's what I said.
All right, go ahead, Mr. Jennings.
All right, thank you, Chairman. Doug Jennings, General Counsel for the department. This motion for rehearing is arising from a matter you considered at your last meeting, in which you decided, you made a ruling to revoke Mr. Walker's licenses on the basis of his criminal history. And in his motion for rehearing, Mr. Walker and counsel continue to, I believe, conflate an earlier case with the present case before you today. Just like to remind you that the case before you today, again, we are proceeding solely on the basis that Mr. Walker had a conviction directly related to the duties and responsibilities of his profession, that the ALJ recommended revocation, that after deliberation and a lengthy presentation, you made that decision to revoke those licenses. I just want to just want to state very clearly, this is about the fact that a criminal conviction occurred, and under Chapter 53, there was a process that we have followed. Mr. Walker has exhausted his regular routes of appeal. No court has found error justifying a reversal or in any way that should lessen your confidence in the fact that a conviction has been reached. If and when that happens, we will come back before you, I'm certain. And again, Mr. Walker will have the chance to file a petition for judicial review of this case if he disagrees with its outcome. And if that court finds any error, obviously we will continue the process accordingly. And so I would recommend that you deny the motion for rehearing. Thank you.
Any questions for Mr. Jennings? Okay, Mr. Gearing.
Chairman and members of the board, in our motion for rehearing, according to the letter from TDLR, we are to list the specific findings and conclusions that we disagree with. 4, 5, and 6 are the findings that we disagree with in the order of 30 January this year. And conclusion number 9 is the one that we disagree with. Let me say that first, in 2014, almost 10 years ago, you considered exactly the same complaints. And the ruling then was to deny revocation of the license. In fact, it was dismissed. And I refer you to the decision of this commission on 29 October 2014, and specifically allegations and findings 22 through 28, and conclusion number 10. 22 through 28 are the exact same facts on which 4 and 5 of your recent decision based. And it's the opposite finding. Now, your own rules. All right, it's actually the Administrative Code Section 155.503 prohibit duplication of proceedings. That's exactly what's happened here. This has already been decided 10 years ago. And so we ask that you reconsider sections or findings 4 and 5 of your decision of 30 January. And number 6, as well as the conclusion, number 9, because the conviction of which they speak is still on appeal. The briefing schedule is actually the record is due in the Court of Appeals today, April the 12th, 2024, in the Court of Appeals for the 9th District. It's still not a final conviction. The materials in this case are voluminous. 5 minutes before you won't cut it. in order to actually go into all of the materials that we have submitted, it's gonna take much more review than that. However, to sum it up and to stay within the 5 minutes that we've been limited to, I just have to reiterate, this has already been considered by the commission in a 6-2 vote dismissing all of these allegations in 2014. Mr. Butler was on that panel and voted to dismiss those allegations. And of course, Mr. Butler was in the minority of the vote January 30th. So I ask that you revisit it and issue the right decision. Thank you.
Thank you, Mr. DeCaren. Any questions?
Anything from council?
Yes, Dr. Weston, just a couple of just rebuttal points. Mr. Walker has exhausted his regular route of appeals. I believe that there is a route of habeas corpus that is pending in court. That is not what you would kind of classify as the regular route of appeals. So we have a final conviction and there's some extraordinary relief being sought. Also, I just want to remind you, this is not a case of where we're painting in broad strokes about some conduct that happened a long time ago. We're talking about a criminal conviction in 2019 that is the sole basis of the action before you and the decision you made in your previous meeting regarding revocation.
DeCaren, County.
Yes, the facts, what they're complaining about actually occurred more than 10 years ago. And we're still here, even though this board found that it should be dismissed in 2014, the exact same thing. I don't know, you know, there's a constitutional provision of double jeopardy, and in effect, the rules that you have to follow, which of course are the administrative code, calls it something else. It calls it duplication of proceedings, but it's the same thing. Double jeopardy. It's already been found that this case should, that the facts underlying this case require dismissal.
Double jeopardy is not implicated. We're not talking about a second criminal conviction for the same conduct. We're talking about a criminal conviction that resulted from some conduct that I think because we have a conviction, we're talking about conduct that happened. Yes, it may have happened a long time ago. The conviction was recent. We are not the body that is in the place to go back and second guess those courts' decisions. They're in a much better position to evaluate evidence and the credibility, reliability of witnesses. We have a criminal conviction. This is not duplication of proceedings. This is an entirely separate action based on a conviction.
Chair, if I may ask, council, based on the fact that, walk me through after this. So their contention is you can't talk about 5 minutes or whatever, you know, the time frame, the rebuttal data, whatever they have. Given the fact what it is, what is the recourse for them down the line?
Right. If you grant the motion for rehearing today, obviously we will start at an earlier point in these proceedings and there will be more time. If you deny, however, Mr. Walker can file a motion for judicial review within 30 days of your order, at which point we can have all the time, they can have all the time they need to present evidence and make their arguments to the court in an effort to overturn the decision.
DeCaren, any comment about that?
Well, I don't think you should punt. It's before you. And just because there is another remedy that is going to district court, if we're dissatisfied with the ruling here, doesn't mean that you should shirk your responsibility and not consider what we say about this already having been decided by you 10 years ago.
Any further questions? Butler?
I have,
It's really not a question, Mr. Chair, and please feel free to cut me off if I go off the rails or if I'm often want to do that, right? And so, you're very gracious in pulling me back. But this has been dragging on for a long time. We've decided this case as a body. There was a conviction after we decided the case, but we need the facts at the time. And to string this gentleman along for what's now 11 years just seems to me like an egregious weight to put upon a human being that's trying to conduct business. We've read this case several times. I don't want to say there was a court shopping taking place, but there was federal cases that were not pursued. There were state cases where they ultimately did it. If you were to pick on an individual and bring the weight of government upon that individual, you're probably looking at the poster child for it in many ways. There's a burden placed upon this man, whether he did right or wrong. We decided that 10 years ago. So we're here to watch out over individual Texans and make sure the system doesn't run roughshod over them. So that's it.
Do you have any comments about that?
I believe we just have a difference of opinion.
Okay.
But the conviction was
Hang
in
on,
2019.
hang on,
Yes, sir.
Dr. West.
Yes, sir.
I was gonna say the same thing for Commissioner Butler. It's like we need to put an end to it. This is just ongoing. If I remember correctly, the school district didn't even want any charges, even after we as the board decided it was okay, go on, move on. It just seems like we can see you 3 times or where we meet 4 times a year. I feel like we need closure so you guys could move on and so we could just move on.
You're about to school.
I want to remind the commission that this is a motion for rehearing. This is not, so just understand that. I know the theme is to counter the longevity of this, but I want to remind people, this is a motion for rehearing. Commissioner, Dr. West.
Well, no, I was just saying, this was, has been shared, it was 2014, but we had a conviction in 2019. So I think that changes the deal, and I'll make a motion to deny the rehearing.
A second?
Second the motion.
Okay. All those in favor say aye.
Aye.
Opposed?
Nay.
I'm sorry. Nay?
Nay.
Nay.
Okay, all right. I'm an aye. So, motion carries. Thank you, Mr. Gary.
Maybe we'd be excused.
Oh, yes, sir.
No. Thank you.
Christine? Okay, Commissioners, we're going to skip the rules, item J, K, we're going to go to item L, please. We'll entertain that. On contested continuation, contested cases. Item 1 now, which is Cody and Mark, please, or staff Mark.
Chairman Doug Jennings, General Counsel. Mr. Cookman's attorney got in touch with us just a few days ago, let us know he was not going to be able to attend for some personal reasons. We informed him that we would request a continuance of this matter, so we can accommodate him. Since this is the first request, it's generally,
Okay.
We generally grant.
Got it. Motion?
So moved.
Second?
Second.
All in favor, say aye.
Aye.
Opposed? Motion granted. Item 2, Ashley Watts and Jerry Burke. Burke?
Yes, sir.
Morning, you've got this. And Don Farrell,
Yes, sir.
you'll be representing Ms. Watts?
Dr. Watts.
Dr. Watts, apologize, Dr. Watts.
Everybody seems to want to demote her before she's out of the process.
I hear you. Thank you for asking. Mr. Watts? Dr. Watts is not here?
No, sir.
Okay. So, Ms. Farrell, you understand the instructions I gave earlier?
Yes.
Okay. Mr. Berman?
Yes, sir, I understand your
Okay.
instructions.
All right, Mr. Bergman, go ahead.
Morning, Commission. Morning, Mr. Chairman. My name is Jerry Bergman. I'm with the Office of the Attorney General. I represented the Veterinarian Board in this matter at SOA. I'm here today to ask you to adopt the findings of facts and the conclusions of law from the ALJ's PFD, and also the modified conclusion of law number 16 from the Veterinarian Board's meeting on March 6th, seeking the revocation of the license of Dr. Watts. Procedurally, we filed this case at SOA on March 11th of 2022. Soon after we filed this matter, Dr. Watts challenged it, sought a protective order based on the pending criminal investigation. That was denied. That issue was brought up again the day of the trial. The ALJ then again denied it. We went through extensive discovery, written discovery. We also did depositions, which led us to our hearing on February 7th through the 9th of 2023. At that hearing, we presented 10 witnesses to meet our burden of proof, which is the preponderance of the evidence that Dr. Watts committed these violations. We called 3 adverse witnesses. One of those was Dr. Watts. She took her Fifth Amendment right to self-incrimination. Because of that, the ALJ is allowed to make negative inference. We also presented 3 experts, Dr. Buchanan, Dr. Dutton, and Dr. Vallon. All 3 of these experts gave testimony while reviewing the video that was presented into evidence of this matter, and all found that Dr. Watts committed violations. That video itself runs just under 2 hours. It shows Allie, the horse that's the basis of this incident, in a stall. And it then shows Dr. Watts use a hot shot, both live with an electrified hot shot and unelectrified as a cattle prod on Allie for approximately 24 minutes. She used that hot shot, and the ALJs determined that her use of it was medically unjustified. She used it in regions so numerous that it would take me more than 5 minutes to tell you. But her chest, belly, her injured hoof, her injured leg, most egregious of all in the face, her ears, her eyes, her muzzle, her underbelly, the perineum area. In response, Allie did nothing. She did not stand. She just tried to get away from Dr. Watts. At no time did she stand. And after about an hour and a half after the last hot shot, Allie died. We alleged initially and at the hearing that Dr. Watts' use of that hot shot was below the standard of care, both in the extent and the duration. The ALJs found for us. They found us in findings of fact 35 through 59 and conclusions of law number 6. They found that the standard of care requires that a hot shot be used as a last resort, sparingly and rarely. They found that another veterinarian acting within the same standard of care would have discontinued use of that hot shot after 5 or 6 minutes. Dr. Watts went for 24 minutes. They also found that Dr. Watts used the electrified hot shot and the unelectrified prod hundreds of times on Allie, ultimately deciding that she fell way below the standard of care in this matter. We also alleged that Dr. Watts performed unnecessary treatment, and her performance of unnecessary treatment was upheld by the ALJ. They found for us on that as well. And that's in findings of fact 60 through 64 and your conclusion of law number 11. They determined that Dr. Watts' use of the first hot shot for 5 to 6 minutes was both unnecessary and excessive. We also alleged that Dr. Watts committed the offense of animal cruelty, that she did not adhere to the law, she violated board rules. The ALJs found for us there as well. Findings of fact 65 through 70, conclusions of law 7 through 10. Determining that Dr. Watts knowingly and intentionally caused Allie unjustifiable pain and suffering. We alleged finally that Dr. Watts kept inappropriate or inadequate medical records. The ALJs found for this as well. Findings of fact 71 through 84, conclusions of law 12 through 13. They determined that Dr. Watts purposefully and dishonestly kept these medical records, and it was in conjunction with her veterinary practice. All of our allegations were upheld. The March board, am I limited to 5 minutes, Commission? I'm sorry, I didn't hear. Am I at that time?
You're almost out of time.
Okay.
You're good. Okay.
And just to sum up, both parties then submitted closing briefs. A PFD was issued on August 26th of 2023. Dr. Watts filed exceptions. Those exceptions were denied. There was a March 6th board recently at the Veterinarian Board Commission in which they unanimously adopted this PDF. All findings of facts, conclusions of law. They did make one amendment, and that's conclusion of law number 16. Initially, it was for a 5-year suspension. They've asked to amend that to revoke the license of Dr. Watts so that she is no longer able to practice in the state of Texas. We ask for you to do the same. Thank you.
Thank you. All right, Mr. Farrell.
Thank you. So first, this case is problematic in that primarily the board's handling of it. The board has allowed, while this body here, this commission agrees that nothing that is outside of the record should be introduced into evidence before the decision makers, the board decided to accept testimony while this case was pending from a member of the public. And over my objection, when I stood up to object, I was told that she had the right to do this, when in fact, you know, she not only didn't have the right, she didn't have the ability. It was wrong. Your own counsel, Doug Jennings, sat there silent, allowed it to happen. So there's already a taint on the board decision that you're here to judge and ratify or not ratify. And for many reasons, including that one, I'm going to recommend that you not ratify it. I think that the emotion that's attached to this case has driven it. The board claims to have these 3 experts. Dr. Buchanan says that he's never been trained on the use of a hot shot, doesn't know how to use a hot shot, has never used a hot shot, has never seen a hot shot used. So I'm not sure how he becomes an expert in the use of a hot shot. Dr. Dutton says that he was never trained how to use a hot shot. He's also a professor at Texas Tech University, College of Veterinary Medicine. He's never trained any of his students on how to use a hot shot. He doesn't know if there's any written standard anywhere about how the proper use of a hot shot in the horses. He does use it, and he can tell you how he uses it, but he can't tell you any standard in the industry, which is what's required of an expert. Dr. Ballin was merely a student at the time of this incident. He primarily practices small animal shelter medicine and has seen a hot shot used twice. Once at the university with Dr. Watts, once with another practitioner where a horse was down, and after one shot with the hot shot, the horse got up. He also acknowledges, as all the other experts do, there's no written standard, and he can't tell you what the standard is. He just says, well, that was too much. And so we're left with these 3 experts, quote unquote, to tell us what the standard is. We, on the other hand, brought an expert, board certified veterinary surgeon, who was there throughout the entire proceeding. She has been trained on the use of hot shots, and she knows the standard of care for the use of hot shots and says that this was used properly. And acknowledges the only reason we're even here is because the horse didn't stand up. If the horse had stood up on the next jolt, we wouldn't be here. The point was to save the horse's life. It wasn't unjustified. We frequently do things that are painful, and we do them in order to save a life. And because it doesn't work in some occasions, doesn't mean it's the wrong thing to do. This expert was excluded as an expert by the court because she hadn't been told that she was an expert. Nowhere in the rules of evidence does it say that one of the ways to establish that a person is an expert is to tell them they've been designated as an expert. That is not one of the requirements. The only requirement is that their testimony is helpful. And I think that somebody who is board certified in veterinary surgery actually has training in the use of a hot shot, has used a hot shot, and so at least has some knowledge of some standard of care for its use, could be helpful to two young ladies who have never performed surgery on a horse. So I believe what we got was an emotional decision. Why else would you exclude that expert? Another person who was allowed to testify as an expert, not even a veterinarian, had never been designated as an expert. But because he said he was an expert during trial, the court allowed him to give opinion testimony about the use of the sling. Again, Dr. Doring, very clear that the standard of care was met.
We need a record.
And then the board, as you know, beyond just allowing improper testimony, Dr. Gola indicated his bias against and foregone conclusion of what the result was going to be by calling her Mrs. Watts rather than Dr. Watts. When he referred to Dr. Copeland in the case immediately preceding, he always referred to him as Dr. Copeland, never as Mr. Copeland.
Okay, thank you, Mr. Ferguson. Thank you so much. Any questions, commissioners?
Well, I got a question on the quote expert, that's board certified. Being in healthcare, there's always obviously the do no harm type aspect. In their testimony, what was their deal? Was 100 uses of the hot shot? Was that within their standard of care?
Who are you addressing this to?
I guess to the
Defense counsel or the prosecutor?
Yeah,
Respondent?
prosecution.
Yes, certainly. And my understanding is I would have some time to rebut. I will directly answer your question,
I'll give you
sir, but do I have some
Let me
time?
address the question.
Yeah, certainly, because it all ties into the experts is where I'm going. Dr. Doring, actually, we tried to exclude her as a witness, as an expert, initially through written motion practice. We were denied. She went into that hearing as an expert witness. What happened at the hearing was her testimony denied her and excluded her. We raised the exclusion after she said she wasn't even aware that she was there to testify as an expert. She didn't understand. She had never reviewed the documents. She had never reviewed, all the qualifications for an expert, sure, but you need to review the documents and everything that goes into the hearing. That's what you're there for, to assist the trier of fact. She couldn't assist the trier of fact. She had never reviewed the documents. It was pretty telling, and I saw Mr. Farrell chuckle there, but yeah, it's pretty telling when you don't tell your own expert that they're there to be an expert. We never heard how many hot shots that she would have allowed within that standard of care. We did hear that from respondent's actual expert, Dr. Green, who was found to be not credible at all. She couldn't give us a number. I asked her if it was 5,000, if it was 1,000. I worked my way down. She could not give us an answer. Honestly, I think there was a testimony within the transcript where she said any amount of suffering is okay as long as that horse stands. That's not the standard of care as far as I'm aware.
I'll give you a minute to rebuttal.
Certainly, thank you.
Any other questions?
I just had a question about the standard of care that you keep referring to, both
Yes,
of you,
ma'am.
but there apparently doesn't exist for the
Right.
hot shot.
Yes, ma'am, I'll answer there too. Within the PFD, the ALJs give a lot of pages to this in your PFD about the standard of care that we were under. The standard of care is what another veterinarian would do, a reasonable veterinarian would do in the same or similar situation. Same type of patient, same type of experience, same type of means at their disposal. So there is a standard of care. It's just not going to say you can only hot shot X times. It's what other reasonable veterinarians would testify to, right?
Is the hot shot considered a treatment?
Yes, ma'am. It was considered a treatment by the ALJs. At no time are we saying that excluded, period. What it was is, what's the extent and duration allowed? And what other reasonable veterinarians would also make that same decision?
So there's no standard of care for that treatment.
That's correct.
There-
I'll answer.
Please give me a minute.
Well,
I think you're
giving me
confusing.
a lot of time to.
I think
to
you're
rebut.
confusing what the standard of care. Yes, sir.
You're giving him a lot of time to
Sir,
rebut.
sir. When I address you, you'll be able to speak, I promise, okay?
Thank you, Mr. Chairman. Ma'am, again, there isn't a standard of care excluding the use of the hot shot, period. There is a standard of care for the use of the hot shot. And that use of the hot shot, with our three experts, every veterinarian we spoke to, other than Dr. Green and Dr. Doring, who Dr. Doring was excluded, all said it's between 5 or 6 minutes, depending on the reaction of the animal. So it's not a hard, fast 5 minutes. It's how the animal is reacting within that 5 minutes. And it's not 1,000 or 100 hot shots. It's 5 to 6 hot shots, and let's see how the animal reacts.
Mr. Farrell.
And so as you point out, there is no standard of care. These veterinarians can't agree on what a standard of care is. In order for there to be a standard, there must be a recognized standard. It can't be something vague in the law. The law requires that there has to be an actual standard if you're going to hold somebody to it. In this case, Dr. Watts was using the hot shot as she had been trained. Dr. Doring observed, and to say that she needed to review some documents to be an expert, she was there. She witnessed it. She heard. All these other experts never got to hear the audio. They don't know how many times the horse was shocked. They just know how many times it was touched with the prod, because you can't tell from watching the video how many times the horse has been touched or hot shotted. It may just be being touched. And it's all part of a training process that Dr. Doring could have explained had she been allowed to, but since all she did was actually observe the conduct and make a rational judgment about it instead of just watching some unaudioed video about it, she was declared not to be an expert. And the judge's reasons, if you'll go back and look at the opinion, the reason is that she hadn't been told she was an expert. Well, that was intentional. And again, that's not a requirement that an expert be told they're an expert. I intentionally don't tell my experts they're going to be experts because I don't want there to be the appearance of woodshedding.
I'm not that concerned about, as concerned about that part of it as you are, I guess, but I was more concerned about the actual standard of care for a treatment. And I think that, the veterinary board would know more about that than I would.
All right, I'm gonna give you guys, any other questions? Yes, Commissioner Turner.
I want to ask a question to Council Jennings.
Yes.
Give me a big overview of this one, all this, how this comes out. Whenever you see a case, someone filed, walk me through the level right there. So the experts, we are not experts in terms of determining who does what it is. The courts are the ones who, the due process works out right there. Fair enough?
Yes, Commissioner Dr. Doug Jennings. So I'll just walk you through, what has happened so far and what can happen in the future. Obviously, we had the complaint that was filed, the investigation, the hearing at SOA and the subsequent PFD, which went before the vet board at their March 6th meeting that they considered and made the recommendations, as Mr. Bergman noted, with some changes to the sanction, a decision to revoke. The vet board generated a recommendation in that meeting. They were recommending that to you, that you adopt their recommendation. If you make a different decision today, that decision will be binding, as will your decision to adopt the vet board's recommendation. Just for the public to know, recent legislation converted the vet board to an advisory board to our department. So their opinion to you is not binding. Their recommendation to you is not binding. It is advisory. And if there is an adverse ruling, if you adopt the vet board's recommendation to revoke Dr. Watts' license, there will be an opportunity for Dr. Watts to file a motion for rehearing with this body, because you are the final decision maker. And then an opportunity, if that motion for rehearing is denied, to file a petition for judicial review in district court.
Thank you. All right. Christine, I'll give you guys each 2 minutes to close and then finish this up, okay? Any further questions? No, thank you. Okay, Mr. Farrell, I want to start with you.
So to address your point, do no harm, right? And also, you have, you're an RN, and you know that there are times in human medical practice where you're required to shock that body over and over again. And who knows when is the right time to stop, right? Will the next shock bring them back to life, or is it time to call it? That's got to be left in the judgment of the person doing the treatment. They're there. They can see how the patient's responding. They can see how this animal's responding. Is the animal acting like maybe it's going to give it a better try here in a moment? Do we continue? And all of this was done in discussion with the owner, and eventually Dr. Watts just called it off. And despite that the owner wanted to continue to try, she said, no, I don't think any more efforts are going to be fruitful. And so they stopped trying. All the doctors agreed that the hot shot had nothing to do with the horse's death. The horse's death was due to something else, which was found only on necropsy, and none of the lab results had indicated this liver derangement that was going on with the horse. So nobody had any way of knowing. She's never been criticized for any of that. Again, Dr. Doring was not woodshed. Dr. Doring, I brought her just as a witness, didn't prep her, just called her and as an expert and got her opinions or attempted to get her opinions until the judges decided that, oh, well, you didn't tell her she was an expert, so she can't be an expert. Again, there's nothing in the law that says that. I don't know if Mr. Jennings will admit that.
You need to wrap it up.
Yeah, given his conduct previously and watching the board that y'all are supposed to be overseeing to allow improper testimony into their considerations. I'm not sure how much experience he has, or I question it because of that. So
Thank you, Mr. Farrell.
Let me just start my clock so I don't overrun. Commissioner Hyde, to get back to your point really quick, on the PFD for everyone, pages 101 to 102, the ALJs actually state an objective standard maintained by average members of the profession in good standing with the same or similar localities and communities, not the subjective judgments of the treating veterinarian. To find otherwise would be to find there is no minimum standard at all. So counter to everything you just heard, it's not the veterinarian in the room making up what the standard of care is. It's an objective standard across reasonable, like-minded veterinarians. That's page 101 and 102 of your PFD. He also brought up the fact that he challenged our experts, that they're not experts at all. Well, Mr. Farrell did not make proper objections to our experts as was required by our scheduling order. He attempted to challenge them live at the hearing, and he was overruled. Our experts provided expert reports. They reviewed all the exhibits, and they provided testimony throughout 3 days of trial. Lastly, I think he mentioned do no harm, and that there was discussions with the owner. Well, we called the owner. The owner disputed that those conversations happened at all, that the word hot shot was never used in any conversation he had with her. Do no harm. That's what Mr. Farrell kept saying. Here we go back to the subjective standard. They keep hot shotting. You never know when is the horse going to stand up? We heard that argument from his expert, who was found to be lacking credibility. Just keep going. I can go 1,000 times. Commissioners, that is not the standard in this state. We're here to protect the citizens of Texas. We're here to make sure that the veterinarians apply proper standard properly in this state. You have the opportunity today to make sure that Dr. Watts never practices again in this state. Never again can she hotshot a horse hundreds of times. We ask for you to make that ruling today. Thank you.
Good, Commission. I typically don't inject in these conversations to try to keep it neutral as possible. But you guys know that I ranch for a living, right? Not for a living, but I have a ranch, and I've had to put down horses many times. And so much like you being an RN, right, your expertise in engineering, and I would tell you that as we go through this case, I don't need an expert to tell me water's wet.
So If you're about,
So let me,
if you're about to
sir,
testify as an expert, I object to it.
but you can't object, sir. You say it, please.
If you're about to testify at all, I object.
I'm gonna, sir, please, I'll have you removed.
I'm making an
Sir.
objection and I'll make my objection and I've made it.
So let me tell you, as a guy who injects my opinion, I want to make sure you understand that, okay? So my questions are not a question, they're statements. I want you to know that. Does that make sense? Okay, all right, so any other comments? Okay, good. I'll entertain a motion.
Okay.
Okay.
I'm sorry?
You gonna make a motion?
Yeah, I'm gonna make a motion to accept the veterinary medical examiner's recommends.
Okay, is there a second?
Second.
Okay, any further discussion? All those in favor say aye.
Aye.
Opposed? Motion carries. Thank you, gentlemen. You have further steps. Okay. Okay, we're gonna take a, back to, you guys good or you want to take a break?
Why don't we take a few?
Okay, we'll take a 5-minute break. It is 10:02. We'll come back here at, let's say 10:15. continue on with the meeting. The meeting time is 10:25. On meeting back to order. Commissioners, we're gonna set up for a meeting on April 24th at 9 a.m. You can be virtual. It'll be based in Houston. You're not able to make
What time?
9?
You can be online, that's for virtual, right?
Can you do afternoon?
10 in the morning.
No, can you do the, can you all do the afternoon? Can we do 1:30? Or 2 o'clock? Is that okay? Let's do 2 o'clock on the 24th. Okay? Mr. Butler, you good?
Yes, sir.
Okay.
Chairman Doug Jennings, General Counsel, we will get with you on the agenda items and get that out, filed as soon as possible.
Thank you, Mr. Jennings.
Yes,
I
sir.
appreciate that. Thank you so much. Okay, Mark Glad, good to see you, sir. Good to be here. We are going to item C. Sorry, let's get around here. Okay, J. Rules, item J on the agenda. All right, Mark, you have it.
Good morning, Commissioners. Mr. Chairman, for the record, my name is Mark Gladney, Assistant General Counsel. The proposed rules that we're presenting today in Agenda Item J are necessary to implement Senate Bill 2304, which was passed in the last session, which amends the Texas Education Code, Chapter 1001, and 84.500 and 84.502 of the Texas Administrative Code is shown in the proposed rules in your briefing materials. And these proposed rules require that the curriculum in each driver education and driver safety course include information regarding the new Tech Driving with Disability program. This new program was designed in collaboration with the department, DPS, DMV, and the Governor's Committee on People with Disabilities to develop informational materials for prospective students with a health condition or a disability that may impede effective communication with the peace officer so that they may be directed to find and receive special education services. Now, this information in the course material will provide an affected person with the option to voluntarily list any health condition with a peace officer on a registration information form or an application for an original driver's license. And it's hoped that with this program that the information that will find its way either on a registration form or a driver's license or an ID card will alert the peace officer at a traffic stop that the motorist has a disability or a health condition that affects the communication with a peace officer at the start of a traffic stop. The information developed by these organizations upon completion will be placed on the department website. And I've handed to y'all what our website, our proposed website is going to look at. You have a copy of that was just presented to you today. And these are the curriculum resources for the DES program that not only include the Texas Driving with Disability program, but the Community Safety Education Act that was passed recently a few years ago, Senate Bill 30. These two pieces of legislation kind of tie together because they both relate to easing the tension that a driver, a motorist would have with a peace officer at a traffic location or a traffic stop. Also the Recreational Water Safety Act, the Julia Wells Act, and also our curriculum materials on human trafficking. So this just gives you kind of a mock-up of what our website is going to look at. And it's gonna look like this, and it'll go on live probably right around the time, the effective date of the rules. So that was that I wanted you to see. And then also the second item that I gave you that's marked communication impediment with a peace officer. This is an excerpt taken from the DPS website. And it gives you an idea as what the process is going to be under the Texas Drivers with Disabilities program, how a person can apply to get this information on their driver's license or on their ID card. It'll be a restriction we place on the back of the driver's license, so when the peace officer takes the ID card or the driver's license from that individual, they'll be able to see, oh, yes, there is an impediment here that's listed on the license or the ID card that says, I'm gonna have to deal with this particular individual in a different manner. So it just alerts the peace officers of what's going on. So this is what's currently on the DPS website. And I just wanted you all to be able to see that this is out there already, okay? So the proposed rules were published in the Texas Register on January 26th of this year. We received 2 comments from parties during the 30-day comment period, which closed on February 26th. One of which was in favor, the other one was outside the scope of the rulemaking. The Driver Education and Safety Advisory Board met on February 28th of this year to discuss the proposed rules and the public comments. The advisory board recommended adopting the proposed rules as they are published. So at this time, staff is requesting a motion to adopt the proposed rules as published with an effective date of March 15th. And that's all I have. Thank you so much.
Excuse me, sorry, great presentation, Mark. I have in our materials that the effective date, we're asking for May 15th.
Yes.
Just wanted to clarify.
May 15th?
You said March. He said March.
Is that what? Did I not
Yeah, he
say?
said March, it's cool.
I said March? Oh. It's really cold in here for me right now. And, stop living in the past. You could hang meat in here, just to kind of keep me alive.
Mr. Chairman, before you proceed with the vote, Mark, I definitely want to echo what Doug said as well. What a very novel presentation. I mean, allowing the commissioners to not only hear what it's going to do, but to see how the information will be presented on the webpage. It really gave a bigger picture of things. So that was really great, man. So thank you so much.
Thank you. For me, Mark, big picture, small words. All right, commissioners, any questions?
Yes, sir. Is this page also going to be on the web or just what we have?
That is a DPS website, so that will not be necessarily there. We may have a link to it, but what you see here, the big thing, that's what's gonna be there. Any other questions? Entertain a motion.
So move to adopt the rule.
Second, May 15th.
Yeah, May 15th, not March.
You have to turn the temperature up in here, so I don't get May and March.
You're taking over my meeting, Mark. Is there a second?
Second.
All right, all those in favor say aye. Aye. Opposed? Good. Mark will get you a sweater. Thank you very much.
Thank you very much.
Okay. Mr. Pello, good to see you.
Good to see you too.
Hello, Lyndon.
Good morning. Thank you. Good morning, Commissioners. Wendy Pello, Senior Assistant General Counsel. The rules before you today are under K, and these are the speech language pathologists and audiologists rules under Chapter 111. The rules that are before you today are kind of a combination of 3 kind of categories of changes that we've combined into one rule package to consolidate rulemakings and make it easier for staff and for everyone to review it in one package. The 3 categories, the first one is changes that were recommended from the Speech Language Pathologist and Audiologist Advisory Board with input from 2 of their work groups. The first change was allowing a licensee to provide proof of licensure to a requester through the department's online license search as an additional option to showing the license identification certificate or identification card, and that helps in situations where maybe they're working in a clinical setting where it's not, it may be a little bit burdensome to be showing cards and certificates. So it helps in especially purposes of telehealth or services outside of an office setting. And those changes came from the licensing work group. The second change recommended from the advisory board is addressing cognitive or cognition screenings as part of the communication screenings and providing that cognitive processes affecting communication function may be screened for as part of the communication screening, and that came out of the standard care work group. The second category of changes we have are the proposed rules that are implementing changes from rule review, and these are select changes. They're mainly just the cleanup changes making clarification and cleanup changes to the existing rules, and then updating statute and rule citations. And then the third category of changes in this package are just technical corrections from two previous rulemakings regarding telehealth. We had needed to remove some remaining in-person supervision references that were inadvertently not removed in those previous rulemakings. So those are the three big categories of changes. We did publish these rules in the Texas Register on December 22nd. We received one public comment in support of the proposed changes, and that comment period closed on January 25th, 2024. The rules and the public comment were discussed by the Speech Language Pathologist and Audiologist Advisory Board, and they recommended that the rules, that the commission adopt the rules as published. And so the department is making that same recommendation to adopt the proposed rules as published with an effective date of May 15th, 2024. Answer any questions.
Any questions? Entertain a motion.
Accept there.
Second?
Second.
All right, all in favor, say aye. Aye. Opposed? Motion carries. Thank you.
Thank you.
Thank you, Wendy.
We are going to go to appointments, Ms. Brady Meyer.
Good morning, Commissioners. Brady Myers, Deputy Executive Director. We have appointments and reappointments for you today. For appointments, we have the Architectural Barriers Advisory Committee, April Polreese, Board of Boiler Rules, Timothy McNulty, Driver Training and Traffic Safety Advisory Committee. Please excuse me if I don't say your name correctly. Gayatri Vasan, Dyslexia Therapist and Practitioners Advisory Committee, Susan Pattison, the Midwives Advisory Board, Michelle Gold, the Registered Sanitarian Advisory Committee, Myron Willie, and for reappointments for the Dyslexia Therapists and Practitioners Advisory Committee, Latricia Nigos and Hector Garcia, and for Property Tax Consultants Advisory Council, Stephen Dunson and Andrea Fahrenholt.
Any motions?
Chair, I want to ask a question.
Yes.
Council, I think in December, we talked about it, to put a conflict of interest statement to protect us, the commissioners. I understand you're working on, what's the status on that?
Doug Jennings, General Counsel. Commissioner Drakshram, as I shared yesterday, you had asked for us to look into a conflict of interest statement. I do have a draft of that. I was hoping to bundle it with some other, you had asked us to look at some other process issues for the appointments and reappointments. I was hoping to bundle it with that. And just being candid, the changes of leadership recently has kind of caused that to take a back seat. But, we're certainly happy to look at that, depending on, what you and Brian discuss, making changes as we see fit, or at least looking at that process. So we'll be happy to be part of that and to implement, that recommendation.
Please, thank you.
Any other questions? Brandy, I will please let these individuals know that their service is appreciated, and thank you so much. Take a motion.
So moved.
Is there a second? Second. All in favor, say aye. Aye. Opposed? Motion carries. Thank you, Brandy. All right, commission work groups. For the HR, I would let the staff know that we're working on candidates right now for the ED. We're whittling down the candidates, and so we'll get back with you as we see fit. So, innovation work group.
Just a quick update. We're moving forward. We're hitting all the dates and marks, and I think we've got a good. John, if you have anything to add to that.
We did have one, I notified the innovation work group that we did give response one additional week that we publicly posted. Responses were due this Tuesday, the 9th. We pushed that out to the 16th because we recognized there was a small deficiency in one of the spreadsheets that they're required to fill out to provide us adequate information. We felt like a week was adequate time to notify everybody, allow them to provide back the proper information that we're going to need so that we can score those. So we'll receive those the 16th. An evaluation team will move forward. We'll have down select, have oral presentations, and continue to work and negotiate that contract for TDLR.
Excellent. All right. All right, Mr. Francis, any other comments?
No, sir.
Okay. Strat plan.
Yes, Chairman, I was gonna ask, and sorry, Brian, I haven't had a chance. Do we need to appoint a work group for strat plan?
Well,
It
right-
was in our schedule, so I wasn't sure.
Yeah, right now we have 3 members that are on the strat plan, but it's just at the chairman's discretion if you want to change that group or not. And it's Commissioner Wesson, Draksharam, and who's the other one? Sorry, I wrote it down. It's on my page. Can't read my handwriting. And Dr. Callis.
Okay, so let me do this. Commissioners, if you want to be part of the strat plan, let me know. And if you already are and you don't want that, well, too, that's tough. So, but we definitely want to make sure that everybody gets the opportunity. So just let me know. And why don't we give you to our next meeting and we'll see.
That'd be great. That'd be great because the first bit of work for them will happen on May 13th. We'll do a huddle just to kind of bring them up to speed on all the information we've had, some of our early drafts for the strategic planning process. So.
Okay. Mr. Jennings, can you put that on 24th?
Absolutely.
That'd be great. I appreciate that.
Thank you very
I
much.
have a question on, John, on our strategic planning that we're talking about with the computers and licensing. There's 3 of us, but he's sending it to everybody. So do we still have committees or does everyone get the information or how does that?
Typically, okay, are you talking about innovation or the strat plan?
No, innovation.
Okay. Typically, what we do is we work through the staff because we don't want to walk in forms. So there'll be a staff assigned to that group. And so the 3 commissioners will work through the group, but the communication will be through the staff.
Correct.
You know, that's speaking.
Are you sending it to all of us or you're not? The licensing?
Just innovation.
Innovation.
Just innovation.
It's innovation. Is that correct or am I?
Yes, sir.
Yeah. I like it when you say that.
We're getting-
All right. Anything else, Ms. Castaneda?
No,
Okay.
thank you.
All right. Excellent. Item O, executive offices.
Mr. Chairman, Brian Francis, Interim Executive Director with TDLR. Just want to bring you up on a few things. Number one, the strategic planning process is going very well. I'm surprised that Jeff and Tila are even breathing. They're in the throes of drafting. A lot of the sections are working with the different staff to get it up there. I'm very, very excited about the story that we're going to be able to tell this time around for TDLR. It's going to be a story of resilience. I was thinking about it over the last couple of weeks. If we were, we're not, but if we were to add a new core value to our list of 7, it would be resilience. That is the value of fighting through, not giving up, recognizing that things are going to be challenging, but still working through. And that's what this agency has demonstrated over the last couple of years. They're just resilient, and I'm proud of them in that way. The other thing, I've got to brag a little bit. It may not be reflected in the person or the body of your interim executive director, but TDLR is number 1 in the Get Fit competition. Our agency won out of the group of 501 employees down to 1. So I'm really proud of the team. So definitely kudos. I want to highlight.
Thanks for keeping me out of
Thank
that.
you. And they made them push it up into the other group. We the 1,000 of employees. So
carefully. Sure.
Yes, sir. I will tip around that. I'm tipping. I also want to recognize the staff again for their trust and their confidence. We had a 93.4% response rate in our survey of employee engagement. We are reviewing it. That's going to be a process. So executives are working on it now. The next phase, we'll have a conversation with the directors. We will then develop teams that will dig deeper because the opportunity to improve is always there. And so we'll have further conversations, but thank you again, staff, for just your willingness to say, I'm going to tell you what to think, and we're going to see if you're going to do something with it. And we will. We'll definitely heed what y'all put in front of us. And Mr. Chairman, I think those are the things I want to highlight. We've got a few folks that are on the agenda with Charlotte and Chris Rusty from the Director of Staff. They'll make presentations. And then Stephen Bruno will back cleanup.
Excellent. By the way, I'd like to do a shout out, if you mind coming in. Tila, I received a astounding glowing remark on our social media. So you're in charge. So great job. Your humor's a little off. I'm not crazy, but I love it. So I'm always entertained. So I know we had a outsider who came to us and told us what an outstanding job you did. So thank you for doing that. Well done. Woo. All right, Charlotte.
Hello, my name is Charlotte Melder, and I am the director of the Compliance Division. I have been with TDLR for 16 years. I've held many different roles. In such, I was the lead prosecutor for a while, I was in enforcement for 10 years. I was a section manager in compliance, and now I've been the director for about 4.5 years. I have absolutely loved my time with TDLR, and as with everything else here, new advancements, new changes, new opportunities are given constantly. And so I have a couple of things that I've been given recently that I have been doing on top of my regular job duties. My favorite and the most pressing right now is being in charge of the attachment of the Texas Veterinary Medical Board, the TPVME. And there have been many advances in that recently. And John can tell you, I've worked with several powerhouses here and at TVME, Brian Francis, John Fowler, Doug Jennings, Tony Kugan, Brittany Sharkey, and many, many others. We finally, I had nothing to do with it, got them a new system that is being implemented, which was a huge step. They are implementing, they have 2 different audits that they're going through right now. We're looking at their website, we're looking at a bunch of different things, and they are just wonderful to work with, and I'm very excited about that and where it's going. It is a lot. There have been challenges, but I consider myself to be super fortunate to be able to do that. And honestly, it wouldn't be without Brian Francis and his leadership in this that has given us the freedom and the trust and everything that we needed. And I want to thank each and every one of you for your decision to bring him back. Thank you very much for that. So before I move on to the Compliance Division, do you have any questions? Okay, so the Compliance Division, you may know, you may not know. I assume everybody knows what we do, but the Compliance Division, although the rest of the agency, every division works very, very hard at what they do, I would consider our division to stand apart in that our job responsibilities are tailored to the industry itself. We do different things for different industries within this division. So for example, our chief electrical inspector does investigations for enforcement because that is what is needed. Or he goes out and checks wiring, or he does presentations to national boards, or he helps write the code. And he's just one of over 80 employees that are in this division. We have boiler inspectors who go out and do technical inspections for boilers throughout the state as a standard regular job duty. We have many program specialists who are the top in their industry, either by license or certification, who go out and do these presentations and are revered statewide and nationwide for what they do. And it's an eclectic group of wonderful folks who work really, really hard. I wanted to highlight a couple of things that are, new to the division. The combative sports group went over to field inspections, all in the last 6 months, by the way. The mold inspector's contract moved from field inspections to compliance. There's some changes, kind of exciting ones coming in that, so stay tuned. The anti-trafficking team moved to the compliance division. And it was decided that our division was going to house all the physical documents for bonds. And James Schooler and Deanna Stewart, who are on my management team, have revolutionized that. They've gone through and found documents from the 80s. We are getting rid of those. We are making sure that everything is complying with the, what is that word?
What's wrong with the 80s?
Oh, no, so did I. But we're getting rid of documents that should be gotten rid of, that retention schedule. So they're doing a wonderful job. So some updates. Our motor fuels program, they have spearheaded working with other divisions because we can't do anything on our own to get another reporting of skimmer violations on our website in a different location. It's still in the old one, but more prominent so people can report skimmers. That is in-house in our division only. The complaints come to us, we go out and inspect, and investigate. And then we report to our FCIC or to enforcement as necessary. They also go out and do trainings. And we're hoping, we just got permission to hire an FCIC liaison, somebody who can take our reports, funnel them to the FCIC, get that information, talk to our folks. So I'm very excited that's coming soon.
Charlotte, could you just say what FCIC is real quick?
Financial Crimes Intelligence Center.
Yep. Thank you so much.
I used to say Information Center, and it's not, it's the Intelligence Center. Starting in 2021, our Elimination of Architectural Barriers group has been working on revising the Texas Accessibility Standards, which is Texas's version that came first before the ADA. We're updating it, we're including things, we had to revise the rules to go along with that. And we took some of those tech memos and we took the procedures and we put them all in the rules. So we're adapting and changing and making things more transparent and updating standards so that they're more clear for the public. We recently hired 3 boiler inspector trainees. Unfortunately, due to there not being a lot of people interested in coming to inspect boilers who have the certification and knowledge, we did lose 3 folks to private industry, making a happy chunk more. And so we posted the positions, nobody applied. And so we reposted them as trainees. We got 3 wonderful folks. We're going to train them up and get them going. And so that was a wonderful little shift that we were able to make, and we hope they stay. The Style and Wellness team has been busy providing outreach, and most recently, they spoke at the International Congress of Aesthetics and Spa. There were about 5,800 people there. 500 people alone attended our booth and asked questions. So it's a very active group. Most of our health and wellness team are still working on some form of bill implementation, working to determine the education standards for the dietitian license because Senate Bill 2016 was vetoed, and other different things like that. It's just wide-ranging, anything you can think of, the division probably does. The compliance ATT, the anti-trafficking team, is co-hosting a cross-divisional meeting with enforcement and field inspections to make sure that the entire agency is on the same page. We're giving out the same information. We have each other's backs. We're reviewing each other's presentations. And our communication has really expanded greatly due to the directors that we currently have in the agency all having worked together. And so it's been really, really nice. And if anybody is still listening on YouTube, at this point in the meeting, we have several positions open, and I will talk to you directly. Go to our website, tdlr.texas.gov, click on employment, look for the word compliance at the beginning of the posting and apply. More to come soon. Yeah.
Well done. Very good.
Commercial.
Commissioners, I'll add something. The compliance division, sometimes it's misunderstood because, licensing does licensing and enforcement does enforcement and field inspections does field inspections. The compliance division, think of it as the glue and as the relationship group. That's the one that has that direct contact with the different industries. They speak that industry's language. We've got the electrician that talks to the electricians. We have the folks that understand how towing and vehicle storage facilities work, and they're out there doing the presentations. While enforcement is doing its number on folks and doing it right and well and appropriate, and licensing is getting them there, compliance is the one that's helping those folks figure out, how do I stay in tune with what's going on with the rules, but also how do I stay in compliance with the provisions out there. They're a voice, they're a counselor, they're a therapist for our different industries, and they play such an important part in helping us do stuff and getting the input of the industries. I've always loved their quality work, but I've always recognized that sometimes they get misunderstood about what precisely is their role. The role is to help us communicate with the industries. It's that simple.
Yeah, Commissioner. Vice Chair.
Thank you. Great job. I know you oversee, a goat rodeo and you do a great job. And I appreciate that. We did have an audit recently of the anti-human trafficking, and it showed some deficiencies, right? And this agency has always prided itself on saying, this is where we fell short and this is where we need to be. and we did fall short. And Brian has imparted that in our DNA, and Bill Coons before. And so we have a tremendous legacy to live up to. Having said that, where are we? Because the audit did find some shortcomings in our human trafficking response, our forwarding some of those notifications to law enforcement. It's something that, obviously we're all aghast at it. Where are we? What's going on?
Okay.
And let's just talk about, where we were deficient and where we're coming up, okay?
Part of those deficiencies were actually brought to light by staff themselves, who reported this is not going the way it should be going, and changes were made before the report even came out. As a result, the group was moved to my division. They had different leadership.
Which brings me tremendous solace.
Thank you. They had different leadership, they had a different goal, they had different tasks that they were doing before they were going out and doing actual investigations on reports that came in. They were working their own caseload. We have taken that away. That is enforcement's job. It is now in enforcement to do those investigations. Enforcement has specific people who have been assigned to work those cases. They have the emergency shutdown order that they have developed procedures for. So that has been taken away from this group. The group that, as it exists now, is an educational group. They are the glue, like Brian had mentioned, to the rest of the division, rest of the agency, and the state as a whole. Sang Hee is our supervisor over that group. She has developed with her staff several presentations that have gone through field inspections, that have gone through enforcement, and that regular meeting that I was talking about, where they talk about the different issues down to what forms that they're going to hand out at presentations, who's going to hand it out, how it's going to work, so that we're all on the same page. We're getting word out. We know who to contact. We have standard phone numbers of who to, when we see it, but the anti-trafficking team as we know it now is not the anti-trafficking unit as it was, because the pieces have been moved out. The inspections, and Chris will talk about this when we get to him, are being done by his staff. The group that is now in compliance is for information gathering and spreading.
And Commissioner Butler, just to follow up on that, only my third week back, I had a very lengthy meeting with Sung Hee, with the group, and she laid out, she provided me with a document and presentation that showed every finding in the agency's response and initiatives to respond to that finding. And so each one has been addressed or is being addressed in terms of a form, a process, or a procedure that's being put in place. So they really jumped on it very, very tight. Yes, ma'am.
I was concerned when I heard the young lady speak about in the cosmetology world, men come and just take their ladies away. Is there a way that when they reapply for their license or are trying, can we have any type of video that they need to study or see before they get their license to know the signs? If we have Uber already involved to know what the signs are, shouldn't we have, something like that for the cosmetology area?
Commissioner Castaneda, cosmetology and barbering were the first of our programs to have human trafficking elements put in their statute. Also continuing education requirements, the signs.
I see the signs, but is there any type of
There's
video?
a CE requirement, a continuing education requirement for manicurists, operators, all the cosmetologists to take. What she was kind of touching on, and I really wish I could have talked to her. She was saying that 1 hour is not enough, and she wanted to have greater detail on what interventions they should do if they see that. The answer is nothing. That is law enforcement. You do not want to put yourself physically at risk with that, as she described it, the pimp that was taking personnel that we've talked to our staff. If our staff sees it, yes, we're going to do what we can, but I do not want them risking themselves physically. We would not develop a video or training to tell our licensees, get out there and tackle the pimp.
No, I just meant the signs.
Yeah, she was kind of saying that, and so there is continuing education specifically for human trafficking for all the cosmetologists.
Any other questions?
And I'll get an update of that spreadsheet.
Please do, please.
That's your vote. Thank you for bringing that up. Chris?
Yes, sir. All right. Good morning, Chairman and Commissioners. My name is Chris Russi. I'm the Director of the Field Inspections Division. Coming up here in a few days, it will officially be 6 months in this position. But even with that short amount of time, it's still like a family. I absolutely grown to love this division, and they do an absolutely great job. They're aptly dubbed the face of TDLR. This is because in programs such as barber and cosmetology, massage therapy, driver education, vehicle storage facilities, these may be the only employees that these licensees ever get to see face to face, unless they get a complaint and then they got Ron's folks coming out there kicking the door down, investigators, blah, blah, blah. But with field inspections, we do look at this as more an educational opportunity. These are one of the very few opportunities for proactive regulation that we have in the state of Texas. And so with that, we take it to have this face-to-face moment to where we walk them through the violations and with the ultimate goal of obtaining compliance. We're not there to kick the door down and everything else. That's what we want at the end of the day is compliance. Now, of course, if egregious violations are found, we will refer those violations to the Enforcement Division through a direct to enforcement or DTE violation and report. One thing about inspectors that they're like, oh, you're just going out there and doing an inspection. Anyone that's actually done an inspection know that very quickly can that inspection turn into an investigation. When we do these reports to enforcement, we're not just sending them a checklist and saying, oh, wrong, 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 wrong. They're actually writing a narrative. They're describing the situation and doing a full investigative on-site report so they can properly cite the evidence of any violations. The division primarily conducts risk-based inspections. I say primarily because prior to the sunset review, all the statutes and rules for the programs that are inspected had a reference to whether their periodic schedule was. For example, massage therapy. Every 2 years we were required by rule or law to do an inspection. Same thing with the educational facilities. Now that the sunset has reviewed the program, they changed up chapter 51.211 actually, and it lays out what risk-based inspections are. They tell us what to consider, whether it's previous violations of law or rule, previous egregious violations through an inspection. And then it also gives us some kind of leeway that we can look at other factors. One thing that we also consider is referrals from outside law enforcement agencies, the Enforcement Division, the Compliance Division. We apply a risk to those, so we will bump them up on the schedule. We also look at the places that have never been inspected before. These obviously, they've never been inspected, so there's an unknown factor on it, which we then assign a risk to. Also, unfortunately, every now and then a business will receive a disciplinary action and then they'll shut down their license and get a new one to avoid that enhanced enforcement action. And so, of course, we want to definitely get out there and see those places as well. Typically, an inspector's week on Monday is their general administration day. So that means that on the previous week, if they had any additional reports they needed to do, they'd fill those out on that Monday. They're then assigned their work plan for the week and they do the research, whether it's in the licensing system, the internet-based research, especially those doing massage therapy inspections. You'd be surprised on by typing in the phone number into Google or the address, what's going to pop up, and that's very necessary information to be able to define the scope of what that inspection is going to be. And I'll talk about my anti-trafficking inspectors here in a little bit, but if they find some kind of allegation of prostitution or something in this research, then we're going to have them pair up. We don't want them going out there on their own, just for the safety factor of things. Also on that day, they're going to do their logistics. They may be assigned 100, 80, 50 inspections to do that week. And depending on if they're in the rural areas or in a highly populated, city, it's going to vary quite a bit. You don't want to go to one city over here and then over here the same day. You want it to logistically be sound, because at the end of the day, we are here to conserve citizens of Texas money. On Tuesday through Friday, they typically go out there and they conduct their inspections. Also within the Field Inspections Division, I have my Operations Support and Analytics section. Within that, I have a management analyst that serves as our subject matter expert and facilitator for the e-inspection system. E-inspections is something that we brought on the past couple of years. It was a big project by the previous director of this division, Eric Beverly. And it is leaps and bounds. It really did bring this division into the 21st century. For those that don't know, prior to e-inspections, we actually had triplicate forms. And you may have been to a cosmetology salon or something, and you've seen that yellow piece of paper that if it's in the sun too long, maybe it's completely black by that point. We were finally able to get out of that. And with this e-inspection system, we can immediately send them that proof of inspection by email. Again, getting out of the paper process and getting into the 21st century, but getting them that report immediately. Also, with the operations support and analytics section, I have 3 trainers. I can tell you that I've worked in multiple divisions, much like Charlotte here at the agency. And the ability to have 3 dedicated trainers is absolutely tremendous. Not only for the new employee that we're onboarding and we're able to facilitate that initial connection, that, okay, we're going to take you here. We're going to set up, make sure you do your onboard trainings that HR and IT are going to make you do, but then walk you through physical classroom training and field training on top of that. In most divisions, you get on there and you learn on the job and you kind of figure it as you go. These trainers are able to create a structured training environment to where, all right, Monday through Friday of this day, you're going to be in the classroom. This is going to be your instructor. All right, this next week, you're going to be in the field with this individual, and then this one and this one. I'm extremely proud of this. I wish every division in this agency could have dedicated trainers because it's absolutely phenomenal. Whenever my inspectors want to learn a new program, we have another structured program for that. If they want to learn massage, they're going to spend a week in the classroom and 3 weeks in the field, learning from the different inspectors and their experience and what they do. I did want to cover a few recent projects and successes. One of those was we reevaluated the direct to enforcement list, recognizing that with the sunset review, enforcement had to do complaint prioritization. And the direct to enforcement list are these egregious violations that we would send to enforcement for them to prosecute because they are a higher type of violation. We went through those and we looked at enforcement's complaint prioritization and saw if these violations actually fell into that. If they didn't, then you know what? Maybe we're going to spend more time on trying to get compliance in the field instead of going for that punitive resolution by sending it to enforcement. We also have gone through the inspection system, and this is something I'd ask them to do, that every violation in the system, you have the ability to hit a switch and say the violation was corrected on site. This is a true testament to the customer service and obtaining compliance in the field. Now I can track that data and I can see which inspectors are actually embracing that core value of customer service and going out there and spending the time with these licensees to bring them into compliance. Another one that Charlotte had mentioned earlier is I was able to hire 4 anti-trafficking inspectors. I'm very excited about this. Their jobs are going to be coordinating with law enforcement and other divisions, taking referrals and inspection requests from AG's office and everyone else. Also collaborating with our regulatory affairs divisions. That's compliance, enforcement, and field inspections, of course. With that, we're able to get on the same page and create a better idea of what anti-trafficking efforts look like for this agency. As Charlotte said, the inspections are done by inspectors now. It makes sense. When I hired these 4 employees, I had a very clear goal. I didn't need the best massage establishment inspector. I didn't need the biggest advocate for human trafficking efforts. I needed a combination of both. I needed someone that had the compassion and the empathy to gain that relationship with the potential victim and work to get that outcry that's so hard to do in a lot of these situations. But if we're unable to get that outcry, I needed them to have the ability and the regulatory knowledge to be able to shut this place down and pursue with that emergency shutdown order and everything else. The 4 people I hired, I'm very proud of. I know that they absolutely fill both of these roles, and I'm very excited to see what they're going to do. They started March 1st, and so they're still new. We're still building everything out, but I'm very excited to see what they're going to be able to do in the future. Any questions on the field inspection aspect before I move to combative sports?
Yeah, that's incredible.
It's great.
So I've been on this commission now 11 years, folks. We were a much smaller agency when I started. When I hear you and I listen to Charlotte, I see our core values play out at every level of this agency. If you embrace those core values, you grow into what a Chris Russi is today. And it's the most amazing thing, Chris, to see you here now and seeing you develop through this agency. My goodness, I look at you and I think, my goodness, it's like I'm listening to an executive director. Charlotte is so calming and peaceful. And I guess what I'm trying to say is to see what we've been able to do in this agency, right? I've got a year left, or a little less than a year. So I'm looking back now. I'm a little bit reminiscent about how far we've come and what has taken us to the gold standard that I think we're at again, right? It's a tremendous legacy. So for the employees listening, these core values mean something. And this is living proof of it. We had a failing in the audit for human trafficking. You didn't wait to be told what to do. You just got on it because you knew that's what's expected. This is where we've always been. We're running the fastest rates. We always have. We stopped for a couple of years, but we're there again. We are the gold standard once again. Thank you. Thank you. Thank you to all of you. You do a tremendous job. I've seen it. I've seen it grow. I've seen it stumble. And I see you stand up again and start running. And it's amazing to just be a spectator on the sideline. And I thank you for making us look good. That takes a lot. I'm not looking at you for
Let me cut it short. Grandpa's good and proud of it. Grandpa's proud of it. He's even more. So I'll let him go ahead.
Mr. Chairman?
Yeah, I want to add something. I think, Vice Chair Butler is saying that when the gold standard, I don't think so. It's called gold standard. We're going to say we are the standard. We are the standard.
Oh, that's good.
Thank you.
Thank you. I didn't finish on a high note, but keep going, man.
Thank you very much, Vice Chair Butler. Those words do mean quite a bit. And yes, I remember when you started on, and at the time I was an investigator in enforcement, and then moving throughout the agency and everything. It has absolutely been a pleasure. So combative sports. Combative sports program, as Charlotte said, when I received the position back in October, November 1st was the official effective date of combative sports in my division. They have a very well-earned reputation of, quite honestly, and I'm gonna come out and say it, they're one of the best in the world. And this is repeated by not only those in our agency, but by other promoters, sanctioning bodies, everything else. They recognize that in the end of the day, Texas is about contestant safety. That's it. I'm not worried about revenue. I'm not worried about if it's going to be an entertaining fight or anything else. I'm worried about the safety of those contestants, and that's it. And that's going to be paramount in our mind at all times with this program. And that's, that testament's kind of been filled with, these larger events that are coming to Texas. We obviously have one later this year, but we constantly have these world-renowned fights, and they want to come here to Texas. They don't want to go to Vegas. They don't want to go to California. They want to come here in Texas. The number of events, we do more than any other state in the nation when it comes to these combative sports events. And again, just a testament to how well we do things here and how much it matters here in the state of Texas. This team of 8 facilitates the oversight and regulation, everything that a typical boxing commission will do. Most states and tribal territories and even countries that are in the world will have a boxing commission. That's what Greg and his team does, and they do a great job of it. They do everything from receiving that initial request for the fight. I only have 6 staff that actually run these events throughout the state of Texas. A lot of times, especially these past couple of months, we've had to say no. Say, look, we're full. We don't have enough staff to do all the events that are being requested of us. Hint, hint, you want to throw some staff around. But we do constantly have to throw some, turn down some promoters because we just don't have enough staff. And that's just a simple, response to it. They take the medical reviews. Anytime a contestant is getting licensed here in Texas, there are certain medical documentation and tests that they have to go through. We collect that information, make sure it's complete. We facilitate the weigh-in, not only weighing in that contestant, but having our ringside physician there to conduct that pre-fight physical. Then, of course, at the event, it's fight night, we're running the event and everything else. I'm not going to go into everything with that just because it would take forever. But if y'all ever want to see the backroom dealings and everything, come on out. We'll put you to work. We'll have you, review some hand drafts and some taping and have you write your initials and everything on there. So please let me know if you have any interest in doing that. I don't want to go too much into combative sports because y'all already do know quite a bit about it. I will say that one of the main things we do, one of the biggest representations of fighter safety is that anytime an event, a bout is proposed, Greg Alvarez and my team will review those matchups. For boxing, you have what's called BoxRec, and that's the repository of all boxing events that are held. All commissions through the Muhammad Ali Act are required to put those outcomes in that system so we can review it. Similarly with MMA, you have combat reg, where that and Muay Thai and some of the other different modalities, those outcomes are placed in there. And so just because someone proposes, hey, I want these two people to fight, I can tell you that does not guarantee that fight's going to occur. We are going to do our due diligence to ensure that fighter safety is held paramount above all things. And I'll answer any questions you all have.
Any comments, questions?
I got a question, and it's also for Dr. Callis. Where are we at on the slap fight process? I mean, is it, I hate to use the word fast track, but I mean, are we staying within the timelines that we need to make this get approved?
I can say, and of course, I'll rely on general counsel for this. Last we heard is that the rule proposal was sent to the governor's office and it was recently approved, but I'm allowed Doug to definitely.
Great, thanks, Chris. Doug Jennings, General Counsel. Dr. Wesson, and Dr. Callis, if you're watching.
He is.
Okay.
He's staring at you.
The rules were approved for publication. And so they were published they were filed for publication this past Monday, meaning that they will publish and the 30-day comment period will begin on the 26th. At which point, after that 30-day comment period, we have an advisory board meeting that we're getting scheduled for mid-June, where the advisory board will take and consider the comments that were submitted during the public comment period, and take those to the advisory board for a recommendation to you. We were originally anticipating putting it on the agenda for your July meeting, but there have been some requests that maybe we cut some time off that timeline, maybe consider it at an earlier meeting. And so we're looking at the timelines and trying to figure that out for you.
Yeah, that'd be great.
And Doug, I think the rule's gonna be published this upcoming Monday.
I'm sorry?
I think the rule's gonna be published this upcoming Monday.
My mistake, Brian, I apologize.
That's all right.
We have a lot of things publishing.
Yeah.
Yes, and so correctly, we're going to file them for publication on Monday. They will still be published on the 26th. That's right. Thank you.
Actually, Mark Gladney sent me a note saying, hey, kind of nudged my boss since he corrected me on the live. He said, correct on the.
Duly noted, Mark.
Are these things in the same type of facilities that boxing matches do, or?
Historically, I have not seen one held in a venue outside of Power Slap's venue.
So what do we have that is considered a power slap venue? Just curious.
It doesn't take much to stage the event. It's one pedestal, another pedestal, a rectangle box.
But the amount of people that attend,
Say
is
again?
that the amount of people that would attend, is that?
It has not been overwhelming at this time yet. That's why they're hoping to come to Texas and get maybe a bigger following, but it's not been a demand.
Because we could go to his ranch or something.
Yeah.
No. My wife would not like that.
Mr. Chairman, I just want to say something real quick about Chris's folks, and also thank you for the kind words about Chris and his development. I think I shared with the commissioners just recently that first directors meeting when I looked at the virtual screen and I'm looking around the room and I'm looking at, and there's a lot of old faces in new places, and I was just overwhelmed and so impressed with the talent that we have at the agency. But Chris's team, they have to exhibit multiple personalities when they're out there. So imagine going into a nail salon. I've went on an inspection with our folks before. There were 21 stations. So there's 21. It was a 2-story nail salon. Some of those licensees have not seen somebody from the agency maybe in 3 or 4 years. And they're all lining up to ask questions. So Chris's folks have to know licensing. They have to understand the customer service side of it. They have to understand enforcement as well as the field inspection side of it and compliance. They have to know a lot, and it is with that licensee lined up. Question number 1, question number 2. And so when people are like, oh, it should just take you an hour to do an inspection. They're doing their inspection in the time period, but they're also providing that level of touch, that high touch for our licensees that may not have one of our folks in front of them for another 2 years. And they've had this burning question about why did your commission, brilliantly, but why did your commission make that rule change, or why did they change the law? His team is dealing with the statutory changes that happen, and they're the ones on the front line. And when he says face, they truly are the face of our organization. And I just respect them so much for what they do.
So reciprocity of business intelligence and industry intelligence is key for our execution of our mission. It is a two-way communication, to say the least. And I know that Brian is alluding to that. So anytime it is difficult, if not impossible, for these 7 members of this commission to wrap their minds around the numbers of industries that we oversee, but to be well versed in them, right? And so you guys have done an extraordinary job in equipping us, as Commissioner Vice Chair Butler said, of making us look a bit, just empowering us with information. And to be able to gather that information, it's impossible for you as well, without the support and the education from the field of the licensees. So kudos. You got 2 thumbs up from Dr. Callis. Just want to let you know that. So he loves you. Actually, I don't think he's ever used that word before, but I think he loves you.
Love you too, Dr. Callis.
Ringside seat.
Exactly. I'll wait for you.
Yes.
I want to echo, I think, whenever we go to these fights right there, the first thing is the promoters, the general counsel, they always come in our staff right there. I think, Chris and Greg, I think, they always say, thank you, they're the best.
Yeah, I agree.
One thing with again, I'll go back to my pet project right there. The fighters always complain that they have to write the checks. They're always saying, can we do a credit card payment? So that's something I request you all to take a look at it, because when your folks are right there getting the scores and all, I don't want them to look at the checks right there, what they have to hand, collect and everything. Because if the check goes in, it's on his name right there. So I want to protect our staff right there.
I know a banker, if they can help you with.
No, we don't.
Very-
We don't.
Asking you back.
We don't need that. Is there anything else? Excellent. Okay. Before I entertain a motion for adjournment.
We'll just see Bruno.
Oh, Mr. Bruno, I apologize.
He's reading the room now. He's reading the room.
Read the room.
Yes, sir, Mr. Chairman and Commissioners. Steve Bruno, Deputy Executive Director. I'd like to give a few highlights for you. I'm going to start with a few numbers. Those numbers are 8, 49, 16, and 63. I'm Deputy Executive Director over licensing services. That comprises 3 divisions, and I've been doing this for about 8 months. I've been with the agency a total of 11 years, much like you, Vice Chairman Butler, not consecutively. And I've had the privilege to be in this seat for just about 8 months. So I'm starting to figure out where things are going, I think. And
Can I have those numbers again?
yes, sir. I'm gonna hit the highlights. They were 8 for my 8 months. Then it was 49, 16, and 63. And I'm going to talk about the divisions that are under my watch.
Those lotto numbers?
I'm gonna play those lottery.
I'm gonna go in alphabetical order.
Bruno, you are not helping my cause, sir.
I need a couple minutes to brag about my folks. That's really where I'm.
You got all the time you need, sir.
And I want to talk about growth. 49 is the number of TDLR family members in customer service. 49 folks. In January, those folks answered 37,000 calls and handled 2,600 emails. In February, they handled 33,500 calls, 33,600 calls, and about 3,800 emails. And this past March, we're here in the middle of April. This past March, handled about 37,000 total contacts, 33,000 phone calls, and 3,700 emails. That's 49 folks. And these employees and these coworkers are the front line on the phone. You're gonna get a lot of calls from cosmetology and electricians and AC and our big programs. And then after a few months, you might get a call about a professional employer organization or a water well driller, and they've got to be ready to take on what's coming. They're also the catalyst for change by sharing what they're hearing with our other divisions and saying, if we've gotten a lot of calls about this, what's going on? Let's see if we can update a form or put some information on the website to make things better for our customer, always keeping our customers in mind. So thank you to the 49 members of customer service. 16 is education and examination. The education and examination division has a history at TDR of dealing with everything schools and school related and everything else. At one point, that's where our public information office was housed. And you can see through the evolution of our agency and our growth, everything they've taken on and they're dealing with. Education exam, some highlights of 2024. We are celebrating the 1-year anniversary of the Texas Massage Therapy exam. As with many programs, when we inherit in a program, we look at what's working, what's not. We knew there needed to be a Texas-specific exam, and so far we've had 44,364 people take that exam. It's cheaper than the previous exam, and it's available in English, Spanish, and Chinese. Again, response to what we're hearing from customers. We want to take these exams in other languages, and now they're able to. We've seen some loss personnel-wise, but the good news in education examination is that we've recently hired 5 new employees since January. We're still conducting interviews for other positions that are open as well. We did have some closures, and this is just sort of a highlight of what they're dealing with. We had 2 driver education schools and a barber and cosmetology school close, and that can be very frightening for students. And so what our staff does is we immediately gather the records, seize any records, depending on the situation of the school closure, and then get to work assisting those students who are our future licensees or future drivers in our state. And so that, again, takes incredible collaboration among our divisions to make sure that we're getting everything we need to those folks at a critical time when they need it. We've got great schools across our programs, but when something bad does happen, we're there to help and step in. And that's what part of what education and examination does. Right now, as you know, one of the secrets to the work of education examination is the decentralization of our exams. You can take these exams across the state. We're working closely with our vendor to make sure. We have heard some concerns about availability, and we want to make sure that we've got availability across the state for everyone who wants to take it, not just in the big areas, but across our state. Just some quick history. When we first got the barber and cosmetology programs, if you were in one of those programs and you were a practitioner, a student about to become a practitioner, you had to come to Austin for at least 2 days and spend time and money here. And then if you failed, you'd have to go back home and then come back. So that's completely been changed, again, to accommodate our customers and our future licensees. For licensing division, and if I failed to mention, that was my 16, was education exam. Now I'll get to the 63, the folks in our licensing division. In January, 18,476 new licenses and 19,000 and 45,000 new licenses and renewed in January. 18,000 and 40,000 in February, and in March, just last month, 16,661 new licenses and 39,593 renewals. That's 63 folks. At the same time, all that stuff's happening, and one of the reasons behind these numbers is growth. I'd like to thank my coworker Jeff Kopis, who's been working on a project to put together some analysis about our populations. And Jeff looked at the past couple fiscal years, the change from fiscal year 21 to now. Our top programs have seen more than 20% growth, more than 7% growth in cosmetologists, more than 10% growth in electricians, more than 7% growth in air conditioning contractors, massage therapists up 20%. The towing industry, an increase of 5%, speech language pathologists and audiologists, an 8% increase. Behavior analysts, a 42% increase in folks. And this 49, this 16, and this 63, those have been numbers constant for quite some time. So despite this growth, the members who I'm fortunate enough to oversee and work with of licensing service and customer service, education, examination, and licensing are doing the job and keeping up with that growth, despite everything else that's been happening. And I just want to say thank you to each of those divisions. The last thing I want to say is that when I first became about 8 months ago deputy, it was just education and examination and licensing, customer service was added a little bit later to my portfolio. Up until very recently, we had one permanent director in those divisions. Now I'm thrilled to announce that as of April 22nd, when Mr. Craig Howard will join our team as Director of Customer Service, we'll have all 3 directors permanently filled in those divisions. And Mr. Howard was able to come to our employee picnic and get a leg up, start to meet his team, his employees. The depth and breadth of his customer service experience in state government and in the private sector is a win-win-win for us at TDLR. We're going to be bringing the best of the best in customer service innovation to our family here at TDLR, and I'm thrilled to share those updates with you.
Excellent.
Yes, sir.
Couple of questions.
Yes, sir.
In terms of customer service, last time we were told that folks have been on the phone for, what is it, time for a couple of hours or something? Where are we? Are we trending down?
We've got each of our agents the goal is to hit about 70 calls a day. And that translates to about 5 or 6 minutes a call. Okay. And those are the numbers that we're trying to adhere to.
Very nice.
Yes, sir.
And also, I understand the licenses, good job, but I still want to see which licenses are being held up or something.
Sure. Yes.
Because what it happens is, we hear this a lot that, the license in particular division or AC or electrician has been held up. So that gives an idea of what's happening.
Sure. Let me touch briefly on that if I may. Sure. One of our biggest issues of processing times that you've heard about from the past few meetings, and this goes back to about October of last year, was elevator reports. We had about 11,000 to get through. Right now, we are working on elevator reports that have come to the licensing division this month in March, which means they're getting through our finance division quicker, coming down, and that number is down to about 2,000, which is a very normal range for us given the number of elevators. And so again, I'd like to give a shout out to the licensing team for that effort. That work has been spread out amongst all the teams for that catch up. And now what our challenge is to make sure that we don't fall back, right? And so we're continuously working and talking about ways to keep that up. Again, with 63 folks.
Yeah.
Good job.
I got a comment
Yes, sir.
too.
Yes, sir.
Regarding the testing centers.
Yes, sir.
I got a call a number of months ago
Okay.
that for some reason, the testing center, nobody showed up to open it that day. And there were 22 people that were signed up to take the test and they turned them away. And I just want to make sure that those testing centers are either penalized or we have something in place.
Yes, sir.
That they've got a backup employee if somebody, because they said, oh, well, so-and-so was sick and they didn't show up. Well,
Yeah.
I'm sorry, these people come from out of town.
Mm.
And I got a call and I think we got it rescheduled maybe a week later. But, I think the centers need to be penalized in some way that they know they've got to have a backup. Maybe they need to have two people there, so that if one doesn't show up, we're still covered without having to call.
Yes, sir.
Somebody to show
Yes,
up.
sir. Thank you.
One last question, Chair.
Yes, sir.
Who is answering the TDLR project management report? Mr. Francis?
Yes, I'll do that. This is for OPPM.
Okay.
Yeah.
For the last couple of months, what we see is some of those IT related stuff at risk or something, it pops out right there. Is there a game plan? Because it looks like we're behind schedule on those. So what's the game plan to get that to a closure?
There's a couple of things, and I'll let John weigh in as well, but we're in a situation right now where our director of that particular division is not present. And so we have moved some of his resources to different areas. The OPPM group has been focusing primarily on the strategic planning process. They're the ones that help coordinate our meetings, whether it's in Houston, Arlington, and Austin that's coming up on Monday. So they've been kind of dedicated to those activities. But on the IT side, I would think that John can touch on, they have been full speed on NLS. A lot of that effort's been on that, but I'll let him chime in. Do you know why you grab a
Specific initiative or project?
I think, on those, basically it's a server 2012 to 2019 server upgrade. There are basically your compliance right there. Is there a problem?
Well, server 2012 upgrade, so my deputy Simon Skebb will be very grateful that you mentioned this in this meeting. It's been a thorn in his side for a long time. Infrastructure, so that's an infrastructure upgrade. It is always challenging to get agency resources at any agency to schedule time to do things that are often routine and maintenance level. That project in and of itself is not, it's critical in terms of, and my CISO also will be very glad that you brought it up, or our CISO, he's not just mine, but we are moving forward with that. I think we are down to just the last couple of servers. It has taken a long time. I inherited that project. We've actually made more progress since I've been here, I think, than they had historically. The team takes credit for that. I had nothing to do with it other than to say, we have to figure out how to do this. It is a large coordinated effort. A project like that is a large coordinated. It's like building a road and sort of saying, well, we need to repave all of your roads in this neighborhood. Scheduling that, getting people to agree to it, because everybody wants the road to be better, but nobody wants gravel all over their truck and all the dings, right? And it takes away other efforts to dedicate people to those projects like that one, as opposed to we have bar cause merge. And often we are the resource constraint. And so we have to find ways to balance that. And what it usually does is lengthen the maintenance efforts for those infrastructure upgrades.
I'm glad you're watching because I'm watching too. Thank you.
Anything else, Mr. Bruno?
No, sir. Thank you. Good job.
Mr. Francis? Good job.
It is just an embarrassment of riches when you see the talent that we have at this agency. It's phenomenal and just a grateful dude. That's all I am.
Excellent. Anything else, commissioners? All right, our next meeting will be April 24th in Houston at 2 p.m. Christine, we make sure that Ivani, the one of y'all, we'll make sure we can get that. It'll be virtual for those who need to be virtual. We've got a couple things to add to the agenda, so.
Yes, sir.
And we'll make sure that that's queued up for us, right?
We're already working on it. We'll have it for your review and right after adjournment. I'd also like to ask, we had slated May 21st as the next, I guess the next meeting. And just kind of wanted to take your temperature on that date. That's Tuesday.
You can have it.
I love the Thursday, Friday thing. Just
Today, Friday would be good, but yeah, I got it down. Let's, why don't we just, confirm with everybody the 24th? But I think that works.
Okay. That would.
24th.
And we'll, yeah, 24th.
I can make it.
It's virtual.
Oh, April.
Yes.
Chair, if I may say something, can we plan ahead on the rest of the dates because with the hurricane season coming in, I need to be prepared what got to be done, so.
I will do my best. I think we have them pretty much, but we need to, and with the legislature, it's always a rolling target, so. You know when the next hurricane?
Right. Commissioner Druckstrom and Chairman, I have a document with our proposed dates.
Right.
And I'll make sure that you are able to consider it at your
Please.
meeting on the 24th, so we can shore that out.
We'll send that out to make sure they're still, and we can adjust as we see fit, but for sure. Okay. Anything else?
No, sir.
Okay. Ryan, you good?
Man, we're great.
Staff, thank you for what you do. Thank you for what you, the efforts that you've done, and we appreciate all that we are in front of and that is behind us both. And we're excited about that. Thank you so much, senior team, for what you're doing. And commissioners, thank you for the last 2 days of your time. Callis, Dr. Callis, appreciate you. It's been a long 2 days, but we plowed through it, so we appreciate that immensely. And I can't tell you that we are we live in an opportunity time, so I want to make sure you guys understand that commission as a whole, people speak of diversity often, especially in this year. Some people think diversity is about racial. I always think about diversity of thought is the paramount of opportunity. As a commission, and I see diversity of thought, that is one of our strengths that people will always underestimate. And I embrace that diversity of thought. So I'm excited about you guys. I'm excited about what we have in front of us. And believe me, it is going to be good. It's going to be good. So with that, I'll take a motion.
So moved.
Second.
Second.
All those in favor say aye. Opposed? Motion carries. We adjourn.